If you intend to testify in this proceeding, please stand and raise your right hand. All those that intend to testify, please stand and raise your right hand. Do you swear or affirm the testimony that you will give will be the truth and nothing but the truth? Thank you. You may be seated. Thank you. How you doing? Do you swear or affirm that you will translate from Spanish to English, English to Spanish to the best of your ability? Thank you. Do you swear or affirm that you will translate from Creole to English, English to Creole to the best of your ability? Thank you.
Buenas noches. Aquellas personas que necesitan ayuda en español, por favor, y van a testificar hoy día, por favor, les pido que se pongan de pie para el juramento. ¿Va a necesitar ayuda? Viene un abogado con usted. Okay. De todas maneras, si quiere, yo le traduzco. Okay. Todos aquellos que tengan la intención de testificar sobre este o cualquier otro asunto, por favor, pónganse de pie y levanten su mano derecha. ¿Jura o afirma solemnemente que el testimonio que está a punto de dar es la verdad, toda la verdad y solamente la verdad? Gracias.
Bonsoir tout le monde. T'as demandé est-ce qu'il y a des gens dans la salle qui ne parlent pas anglais bien, qui ont besoin d'aide avec l'anglais? Pas de monde? OK, merci.
Thank you. I'll go ahead and call board attendance. Calling Chair Yvonne Bayona.
Here.
Thank you. Calling Vice Chair John Cunil. Calling Member Brenda Bettencourt.
Present.
Calling Member Christy Tasker. Thank you. Calling Member Keon Williams.
Present.
And calling Mr. Rick Madan.
Present.
Thank you. We do have quorum.
Okay, these brief statements will be provided by the counsel to the board.
Good evening. I would like to welcome you to this meeting of the City of Miami Code Enforcement Board, or the CEB. The Code Enforcement Board is made up of 7 regular members and 2 alternate members appointed by the City Commission who volunteer their time and services. The board is authorized by Florida law to hear and decide cases brought against those persons who have been cited for violations of various city ordinances, but who have not corrected the alleged violations. Each case will be called based upon when the property owner or representative has checked in and the type of matter to be heard, unless there are extenuating circumstances. The respondent whose property and or business is the alleged violator will be asked to plead guilty or not guilty. If the respondent pleads guilty, the board may impose a fine against the respondent or respondent's property of up to $250 per diem for a residential property and up to $1,000 per diem for a non-residential property for a first-time offender, and up to $500 per diem for a residential property and up to $5,000 per diem for a non-residential commercial property for a repeat offender. If the respondent pleads not guilty, the City of Miami, through the Assistant City Attorney, will present its case. After the city presents its case, the respondent will be permitted to present its defense. Both the city and the respondent will have an opportunity to present evidence and to examine and cross-examine witnesses. If the respondent is not present and the respondent's representative wishes to be present, the respondent's defense to the board, a signed and notarized power of attorney, is required before the case will be heard. If there are any representatives present without a power of attorney, please immediately obtain one or contact the respondent so they present their defense to the board. If you fail to do any of the above, the board will proceed to hear the case in absentia. This hearing is conducted in an informal manner. There are no formal rules of evidence. However, all discussion, presentations, and questions are limited to the matters relating directly to the violation cited. After all the evidence is presented, the board will determine by majority vote whether the respondent is guilty or not guilty. If the board finds the respondent guilty, the board will order the respondent to correct the violation by a certain date. If the violation is not corrected by that date, the board may impose a fine against the violator or owner of the property of up to $250 per diem for a residential property and up to $1,000 per diem for a non-residential property for a first-time offender, and up to $500 per diem for a residential property, and up to $5,000 per diem for a non-residential property for a repeat offender. The respondent may also be charged the cost of prosecution and up to $5,000 or $15,000 for specified code violations as a one-time fine for violations that are considered irreparable or irreversible in nature. It is the violator's responsibility to notify the City Code Compliance Department when the violation has been corrected. If the violation is not corrected by the required date, a lien shall be imposed without further hearing. The lien imposed will be a lien against the cited property and against other real or personal property owned by the violator. That's it. Thank you.
Calling our first case. This is a code check agenda. This is page 88, to be heard. Address is 3200 Thomas Avenue. Case number 000-74991. Address 3200 Thomas Avenue. Page 88, to be heard in the code check agenda.
I'm sorry, could you say what page it is?
I'm sorry, page 88.
Okay. Yes. Okay, Madam Chair, we have a representative from the Tree Preservation Department here, so we're taking it out of turn. The case was properly notified. He's here to testify. Our inspector is also here to present her case, so we're requesting that you approve our presenting the case in absentia.
Yes, I approve.
Okay. Inspector, please state your name and official position.
So speaking to the mic, make sure it's on. There you go.
𝐂𝐢𝐭𝐲 Smith, Code Compliance Officer, Inspector.
Okay, and did you issue a citation to the property at 3200 Thomas Avenue?
Yes.
Okay, and did you provide me with your file in this case?
Yes.
Okay, and what we've marked as Exhibit A are your notes, the exhibits, and the photographs of the violation, correct?
Yes.
And Exhibit B are the records of the property appraiser, correct?
Yes.
And Exhibit C are the official notices and summonses required by Florida law.
Yes.
We'd like to introduce A, B, and C into the record.
Submitted.
Okay. And did you cite the property for failure to take the necessary preventive action in order to protect the mature trees on the property?
Yes.
Okay. And did you I want to say, were you called out to the property at 3200 Thomas Avenue?
Yes.
And did you cite them on January 4th, 2024 for failure to take the appropriate preservation measures in order to protect the trees?
Yes.
Okay. And at this time, Madam Chair, we'd like to have the representative from the Horticulturist Department in order to provide the testimony as to the failure to preserve and protect. I think you brought some photographs, correct? Okay.
Welcome. Please state your name and address.
My name is Sean Smith, 814 Northwest 20th Avenue. I'm an environmental resources specialist too, ISA certified arborist and a LIAF certified landscape inspector.
Okay, could you tell us who called you out when you reported? What did you find? What were your findings? And if you have any records or photographs you wish to share with the board?
Yes. I was contacted October 10th by Dr. Teresa Tremansky, who lives on an adjacent property sort of diagonally across the street. That was October 10th. And then I visited the property on October 11th. I did not have access to the site, but I took photos from outside of the fence. I then returned to the property on January 8th and again on January 19th.
Okay.
And I have some photos, as you
Okay.
mentioned.
If
and
you
the
give them to
original
me,
email.
I will go ahead and provide them to the board members. And please continue with your presentation.
Okay. So we're referring to tree number 3, which is identified originally as a 31-inch DBH specimen live oak. And as I mentioned earlier, I received a call and a text message from Dr. Teresa Tremansky, who resides at 3211 Thomas Avenue, informing us of the lack of tree protection fence as well as equipment that was stored within a few feet of the tree trunk and the tree was already exhibiting a little bit of dieback at that time. So I conducted a site visit October 11th, and as I mentioned, was not able to enter the property. I took some photos which are uploaded to the case file. I observed at that time that there was no tree protection fence around any of the existing trees, and Dr. Chermansky provided additional photos in the email that is included.
Yeah. And did the tree ultimately die?
Yes, the tree ultimately died. When I went back out on January 8th, the tree was dead. There was still not adequate tree protection fence, which you can see in your photos, as well as all the equipment stored in immediate proximity to the tree trunk. In addition, there was pruning conducted that's not in accordance with our code, which is Chapter 17 and anti-A300 standards.
And a tree of that size, how long does it take before a small oak tree grows to that size?
A long time, 80 plus years maybe, you know?
Okay.
Long time.
So it's fair to say that the damage done to this tree and to our treescape in the city of Miami was irreparably harmed.
Oh, yeah.
Okay. And could you please tell the board your credentials, your background?
Sure. As I mentioned, I'm an ISA certified arborist. I am also a certified landscape inspector with the Landscapers Inspectors Association of Florida. I've been with the Environmental Resources Department for 2.5 years. Prior to that, I was with Montgomery Botanical Garden for 2 years.
Okay, thank you. On the basis of Florida statutes and our city code, we're requesting a $15,000 irreparable harm fine, as we will not be able to replace that size and canopy in our lifetime. And we're requesting that they be given 3 days to come into compliance and $500 a day thereafter until compliance is achieved.
Do I have a motion?
Madam City Attorney, is that the maximum fine that we can fine them, is $15,000?
That is $15,000 for the irreparable is the maximum, and $500 a day is the maximum we can do on a residential property.
Even though it's not homesteaded, it's
73.
Even though it's not homesteaded, because we're
33.
following procedures of our code and Florida statutes.
Okay.
That's the most for the first violation.
I thought we could fine up to $1,000 when it's not.
Well, we can fine up to $1,000
Per day.
Per day after we find them as a repeat.
Offender.
So-
Okay.
So it's because it's a residential. We're trying to be conservative.
Right.
And so we believe that the irreparable harm is going to send these property owners a message. They have 3 days to pull the necessary permits to put a replacement tree on. They had notice. They were cited in January. They were aware since October of last year that what they were doing was in violation of our code. So they've had more than enough time to come into compliance with the city's codes.
Through the chair.
Did you want to
I have a
add
question.
anything
I
else?
wanted to ask you a question. Is that in addition to, because the project we're reviewing now and is relocation?
It's in addition to.
Yeah.
This is a
Separate.
violation.
Right. Okay.
I'm sorry.
Yeah, I have a question. Well, 2 questions. The photos that we're looking at here there's 2 dates. One that says January 8th, 2024. And the other one says, I believe it's an error, but I believe it's October 10th, 2023.
Not an error. There's 3 different times I visited the property. October 11th was the first time.
2023.
2023 that
Gotcha.
I visited the property. I went back again on January 8th and then again on the 19th.
Understood.
And I was accompanied at that time with my colleague Augusto Carvajal, who was also, he's a track certified, ISA certified arborist, and he accompanied me along with the 2 code compliance officers.
Do we have, and my question only just wants to just try to have clarity here.
Yes.
Today would probably be about 3 months from the last time the photos were taken. We don't have any current photos of the picture of the tree today.
The last time I was out on site, January 19th, the tree was in the same condition as January 8th. It was already dead. The improper pruning had already taken place. There was still no, it was already dead, so the tree protection fence at that point was irrelevant. So they had already killed the tree.
Yeah, Just me, I think it would, for me, it would have been a little bit more helpful because at some point, they're probably going to try to come back before the board.
They can't come back and say the tree is not dead.
Well, Director?
So, to the point of Ms. Tasker and the chair, there are times that we want to be a little bit more prudent. The last thing we want to do is exceed the amount, have them come back, appeal to 11th,
Correct.
and they prevail.
Correct.
We don't want that here. So the $15,000 irreparable, we're absolutely
Right
on
on.
the same page.
Right.
And that,
And
You
do
know-
you recommend $250 a day or?
no, I think $500, we're going to the limit. I think that's fine. I think if we went to 1,000, I would feel uncomfortable. But the $500 a day, I think that's our recommendation.
Are there any other further questions?
Just a question. How much it will cost to replace a tree at this site? And the reason I'm asking the question is because they have to replace it supposedly, but sometimes you're not going to find that type of tree. So if he has to replace it, if not replace it, how many trees do we have to plant to actually replace this one?
It would be substantial for sure in accordance with our code. I can tell you that there are projects in the immediate area that have similar size, and that's why I asked the question, specimen live oaks, and we've put the owners in contact with them. And earlier today, I made a phone call to the arborist involved on that project, and they had not reached out to them yet. But it's literally a couple blocks away that they could relocate the tree. And so they have made no effort to do that as of today.
Thank you. Any further questions?
No,
I have
I'll
a
make
motion?
a motion. I'll make a motion for $15,000 a day, $500, it's $15,000 a reputable, $500 thereafter.
And 3 days for?
3 days.
Okay,
Find
do I
the
have a
property
second?
guilt?
To come
Second.
All in favor?
Aye.
Thank you.
Thank you.
Calling next case. This is a code director special item. It's not on the agenda. The address is 801 Northwest 3rd Avenue, Unit 101. Case number is 000-34531. Address 801 Northwest 3rd Avenue, page 101.
101.
Yeah, it's not in our, I'm sorry, it's not in our
book.
agenda. It's a special
Okay.
item.
This is an item.
Okay,
Good evening. Can you please state your name and address?
Good evening, board members. 𝐂𝐢𝐭𝐲 with offices at 2800 Ponce de Leon Boulevard, the firm of 𝐌𝐢𝐚𝐻, and I'm here on behalf of MTZ Carver LLC, which is a subsidiary of the historic Mount Zion Missionary Baptist Church. As you may know, the historic Mount Zion Church is an eleemosynary 501c3 not-for-profit organization. I want to thank the city and the director for the opportunity to be here on a special appearance. We're here for case 000-34531 for the property at 801 Northwest 3rd Avenue. This property is a 3-story building with 10 apartments. 2 of them are 1-bedroom, 8 of them are 2-bedroom, owned by Mount Zion Church. The building has 3 commercial spaces on the ground floor, and these spaces are used to subsidize the apartments, which rent for no more than $1,200 a month. We're talking about a building that serves very low-income residents. We're here today because there was a violation issued for a sandwich shop that had operated in one of the ground floor units, the commercial units. They failed to get a certificate of use in BTR, and they were brought to this board June 1st of 2023. And during that hearing, they were heard in absentia, and they were issued a $15,000 irreparable fine and given 5 days for compliance with a $5,000 per day fine thereafter. And this went in as a repeat case because another tenant previously in one of those spaces, not the same violator and certainly not Mount Zion, had also at some point failed to have a certificate of use in BTR and had been cited previously. Now, June 6th, so 5 days after this board imposed the fine and adjudicated them guilty, the sandwich shop had been closed and vacated, and that's confirmed by Inspector Jansin's case comments in the system. So the case was actually complied, as confirmed by the inspector, within 5 days of having been heard by the board. which is important because the board granted 5 days for compliance before the fine should start. However, for some reason, the case remained open and the fines ran, and they ran all the way until March 20th, 2024. That's 3 weeks ago, give or take. We don't understand exactly why, but I spoke with the code enforcement, with the code compliance inspector. I've also spoken with the director, and I think we're kind of agreed that the math comes out that this fine should never have run, okay? And I believe the inspector agrees with me that that part of the fine should definitely be zeroed out. And as far as the irreparable harm fine is concerned, I'm just going to say that I think $15,000 for something, you know, that Mount Zion itself did not have a hand doing. I understand that the fines, because, you know, you can't go after the business that up and disappears, falls on the property owner. We're talking about a non-for-profit organization that does a lot of good for this community, and having them get hit with that sort of fine doesn't help anyone. It's far beyond what is necessary to give you know, to teach them a lesson or to somehow punish them for what happened with one of their tenants, who they very diligently, as soon as they saw what happened and what happened at this board, got him up and got him out. So I understand that the director has a position he would like to make, and I would be happy to hear his.
So before I do that, I see you have Dr. Cap that
yes,
came with you.
I'm
Dr.
sorry,
Cap?
with me is Dr.
Yeah.
Cap from Mount Zion.
Yes, I'm the executive director of Mount Zion Developments, and we own the building along with the church.
Tavares Moreland, who is the property manager.
How you doing, board? Good evening. I'm property manager for the past 10 years.
So I have discussed the matter with, as a matter of fact, it was triggered by District 5 to my attention and discussing with council. So based on the information that he's provided, the compliance took place within the 5 days. So the accrual should not have taken place. And part of the recommendation that I'm going to make to the board is that you dismiss that portion. Now, it comes to the issue of the irreparable. And when we first adjudicated, clearly our concern is when property owners don't properly vet their tenants. But we have to maintain in this specific case, and we have a duty to do a case by case. It's a 501c3, a private not-for-profit. They do a lot of good in the community. Now, I was going to make a recommendation to reduce the $15,000 to $1,000. But the council correctly, and I'm going to yield to him in a second, he's going to go ahead and reflect that the code does not allow for that. That's his position. I'm going to say that we have the ability. It's a 501c3. I'm reluctantly saying let's reduce it to $500. But council believes that this is a binary option, that since the violation was corrected, it shouldn't be in place. So I'm going to recommend 500, but I'm not opposed that you consider zeroing it out. Council?
Mr. Director, thank you very much. I yield to the board for their comments, and certainly happy to answer any questions you may have.
Madam Chair?
Do we have any questions?
Motion.
You have a motion?
Yes. Motion for 500.
Do I have a second?
I would like to discuss his motion because I would like us to make a motion. The last hearing, we, for a 501c3 church, the Archdiocese, we didn't charge anything, so I would like us to consider.
Right, give me 1 second, because once we have one motion, we have to wait if there's a second. If there isn't a second, it'll die.
I will withdraw the motion.
And then you can bring up your motion.
And I'll make a recommendation for zero.
I will second that zero.
Are you making a recommendation or making a motion?
Making a motion for zero.
Okay. I second the motion. Well,
I'm sorry, so we have a first and we have a second?
Yes.
Discussion?
Correct?
Yes.
All in favor? Aye. Zero it is.
Thank you very much.
Thank you. Take
Wait
care.
for your
Thank you
order.
for everything that you do for our community. Much appreciated.
Thank you. Okay, thank you so much.
Next case, please.
Just a moment.
And you were right, Chris.
Calling page number 171. They're here for 171 and page
Wait for your order.
There is no order right now. Calling page 171 and page 173. The address is 2136 Southwest 5th Street and also 2128 Southwest 5th Street. Case number for 2136 is 000-71671. The case number for 2128 Southwest 5th Street is 000-71658. Page 171 and page 173.
171 and 173?
Yes, 171, 173.
Do we have the property owner here? Oh, we have the attorney. Hi, how are you? Good afternoon. Please state your name and address.
Good afternoon, Mickey Marrero, here representing Little Havana Multi Holdings, the alleged violator. And my address is 200 South Biscayne Boulevard.
Thanks. If you can speak closer to the mic, because I can
Yes.
barely hear you. Sorry.
Mickey Marrero, here on behalf of the owner. My address is 200 South Biscayne Boulevard.
Okay, this is to be heard, correct? Guilty or not guilty?
To be heard.
You want to hear them separately or both? It's just kind of, they're both next to each other. They're both guilty.
I think
Okay,
we
let's
hear
do one at a
them
time.
separately, just in case
Okay.
that you reserve your
Yeah,
rights.
let's do one at a time. So we're going to do the one on page 171 first. He said guilty. We'll let the city present its case.
Go ahead, Inspector Jensen, provide a synopsis of the case.
𝐂𝐢𝐭𝐲 Code Compliance Central. BCU unit, I'm sorry. Yeah, I cited the property for no CU and BTR, and basically they were cited before, not legally. They were giving like a notice of violation, a handwritten notice of violation. So basically, I follow up with what the previous inspectors done. So I cite them now, recently. So basically, they still don't have a certificate of use. I just find out with the attorney that they have a situation with the building, apparently working with the 40 and 50 years recertification. So that's what takes them a little time before they can get the certificate of use. So I recommend, since he explained why, I recommend 90 days.
And a fine of?
Yeah, and just,
Counsel?
yeah, I spoke to her before. We showed her the documents. We have an unsafe structure case, and we're fine with 90 days.
Fine with 90 days?
I can explain more if you
Okay.
need.
Do I have any discussion?
Question, yes. How long did he has the 40 years application in process? It's been
So-
a year, 2 years,
We
2 months?
What happened is it goes over a year. Their architect got COVID and we had to get a new architect. We went to the Unsafe Structures Board in January. We're within the timeframes. They're actually way ahead of their schedule in unsafe structures, and we're going to comply. We have till the summer to comply. We hope that we're going to comply in like June, but they're very close. And until we get that closed out, we can't get to see you. Correct.
No, I just, since you say COVID is 2019, we're in 2024.
No,
So
no, but
5 years is a long time.
The gentleman is in his 70s, and he got it last year. People are still getting it. It wasn't back then.
So we're recommending guilty, 90 days, $500 a day thereafter.
Do I have any other questions?
Yeah. Do you think you'll have that done in 90 days?
It's already well in the process. We went to hearing in January. They have a compliance date of June for the unsafe structures.
Right.
We're hoped to be done. Once we're done with that, we can then reapply for the CU, go through the inspections. So I think we can have the unsafe structures done in probably less than 60, maybe 45, but then we have to apply for the CU, and that takes a little time. So I do think we'll be done in 90.
So to Mr. Williams' point, because what we want really is to reduce the docket. I'm sorry, Mickey, we'd rather not see you here back for this case.
Right.
So I'm going to amend the recommendation to 120 days and a fine of $500 per day for every day thereafter.
Any further questions? Do I have a motion?
Make a motion for 120, $500 a day thereafter.
Do I have a second?
Second.
All in favor? Aye. 120. Next case. Please state your name and address.
Hold on, Melanie. Go ahead, Melanie.
Page 173.
Okay.
The address is 2128 Southwest 5th Street. Case number 000-71658. Page 173.
So this is essentially the building next to it.
Name and address again, sorry.
Mickey Marrero, 200 South Biscayne Boulevard, here on behalf of the same property owner. This is 2136, that was 2128.
Is it guilty?
Guilty, and essentially the facts are the same. So
Any discussions? Do I have a motion?
Motion for 120, $500 thereafter.
Second.
All in favor?
Aye.
120.
Thank you.
Thank you. Next case, please.
One more?
No, that's it. 1, 2.
He's still here.
He's also here for an extension of time. This is in the City View agenda. This is page 26, extension of time.
So may I interrupt for a second? Because he not only has an extension of time, but he has a mitigation. So sorry, Mickey.
I'm back, it's fine.
Yeah. Come back. Let's go
Let's
with
move forward.
all the new cases first, and then we'll plow through the rest.
Okay.
Okay?
Calling
Thank you.
page 33. This is a to be heard in the code check agenda. The address is 1200 Northeast 87th Street. Case number 000-77422. Page 33. The address is 1200 Northeast 87th Street.
Page 33.
Good afternoon. Please state your name and address.
Good afternoon. Again, 𝐂𝐢𝐭𝐲 with Office at 2800 Ponce de Leon Boulevard here on behalf of the property owner.
Guilty or not guilty?
Guilty, and this is a case which we have also discussed with the director, and we are in agreement on how compliance will be achieved.
Okay, can you give a little bit more on that?
I'm sorry. I was looking at the... no, I'm going to go ahead and yield to the co-compliance inspector Encinosa, and we'll discuss. You have the ability, counsel, to explain later. We have been discussing it at length, but we are ready to go with full explanation.
Understood.
And there's support evidence or somebody from the neighborhood that wants to provide her testimony. So we're going to...
Counselor just said that he discussed it with you and that you both are in agreement.
in agreement that he is no contest, he's not guilty, and we're going to go ahead and provide our synopsis.
No, he said guilty.
I said guilty.
Yes. So,
okay.
Go ahead.
So do we want the explanation?
No, I want the entire presentation.
Inspector, please state your name and official position.
Good evening, Eric Encinosa, Co-Compliance After Hours Division. Try to give you the chronological event as best I can. Basically, this came in as a complaint on the After Hours hotline. I responded to the location. It was made by Miss Ashley Callis, who's here tonight. I met her at the location. She's the neighbor. She lives next door. She granted me access to the property, and I recorded with my body cam. I have the body cam video here as well. Around the 4-minute, 50-second mark, she called the neighbors over to the fence line, and they basically admitted that they were short-term renters. Based on that testimony, I opened a case. I cited for illegal short-term rental and use not allowed in transit zone. In the subsequent follow-up period, she provided me with several other short-term rental links. At the time, there's also exterior photos which actually show the address. It's clearly visible that that is the location. Once I cited, a few days later, I was contacted by the property owner, who's also the registered agent. He told me that he was not engaging in short-term rentals. I asked him to send me a copy of the contract. The very first contract he sent to me was a blank document. I told him, this is not a valid contract. Do you have a valid contract? Then he sent it to me. It was a 6-page document with the signatures. There was no other supporting evidence other than those signatures. I made him aware that the short-term rental cases had to be heard. They had to come to board. Then I advised Ms. Callis and the other neighbors in the neighborhood, if they had any continuous problems, to call police non-emergency or report a complaint to us. I couldn't open a new case afterwards, but there were other violations subsequently that took place throughout the time. I was not present during this time, but my supervisor and senior inspector, Supervisor Cornelius Pierre, Senior Inspector Randy Caesar responded to that call because it was made at police request. There was a talk of a party bus. There was a catering vehicle that was parked there, vehicles parked in the street. I did not respond to that. Ms. Callis will probably give you more details regarding that. But they continued to call in the complaints, and we continued to investigate them. The last case that I came upon was the vehicles that were parked in the right-of-way. One time I arrived there, it was a Tesla Cybertruck, which is a very unique vehicle. It's a silver vehicle. You can't mistake it for anything else. There was 2 Rolls Royces, and there was a SUV that was parked in the street. The Tesla Cybertruck was halfway on the street, so I didn't include that in the violation. I only issued a $50 ticket. The violations continued. That's when the attorney, I believe it was Mr. Arango, contacted me. And we had an exchange back and forth. He asked me to go by and verify that the violation had been complied. I went by the following day. The Tesla Cybertruck was still there. The Rolls Royce was parked inside the property line, but there were more vehicles outside on the street. I sent him photos regarding that. And throughout the time, I've been collecting the links. Now, regarding the short-term rental. Regarding the short-term rental, I have a total of 13 links. The first time there was a for rent link for Airbnb. The Airbnb link, as of now, has been deactivated. The realtor.com link, which is the second link up there, was for rent exclusively. It's been added to for sale. The third link, which I listed on the Excel spreadsheet as short-term rental, that one is still active. That is the only link of all the links that is exclusively short-term rental. It's for $4,750 a night, 3 nights minimum. They have some specific, at the top of the page, specifically for certain times like Art Basel, but the address isn't listed, it's listed as via Ipanema. So you can see underneath on the picture right there where the listings are, and all the images match up with the photos that I've collected throughout that time.
So for the record, and I think I want to, because they've already admitted to it, I want to hear from the member of the public who's been adversely impacted. But one of the discussion points that I had with council, go back to the picture, because it said Miami Shores, that is to throw off the scent. If you go to the first picture, it has the facade, it matches the pictures from the inspector, the 1200 address, and that was part of my discussion with council. I said, look, we have sufficient evidence. We're going to hear now from an adversely impacted neighbor. But the agreement with council is that we would, if they admitted to it, that I would not seek the irreparable. Clearly, the highest amount per day, and they'll have 5 days to do that. But that's the agreement. So I'd like to go ahead and speak.
One final point,
Yes.
just to make it clear. The property in question, and Ms. Callis' property, is the edge of the city of Miami boundary. You cross the street, it's Miami-Dade County. That's how far on the edge they are. So it's right next to Miami Shores.
Ms. Callis.
Thank you.
Hi. So,
Good afternoon. Please state your name and address.
Ashley Kalis. I live at 1200. 1250 is our address. 1200 is the one in question. So I can talk about the experience has been, this neighborhood, especially the street, has been impacted by short-term rentals for years now. I recognize some of the members here today from another hearing. A lot of the neighbors are elderly, so can't make it here. And I'm able to come down here and have a conversation because this is really impacting the neighborhood. I don't know what the agreement was with irreparable harm or whether, and that's beyond my ability to get involved, but if you can consider finding, because this is not somebody who is a homeowner who's trying to pay their taxes or trying to pay their mortgage. This is an individual that is specifically in the business of building houses and renting them out. As soon as they got their CO, they immediately put it on Airbnb. This owner, well, council told me, we spoke, he doesn't know this owner, which is convenient. You can't ask him anything, you won't know anything about this specific owner. Has 3 other cases open. 2 were not by me in different areas in Miami. 2 out of the 4 cases are waterfront properties that are near us. This is somebody who takes them off so they can comply, they know the game. We were told by the property manager that this is the cost of doing business. You are the cost of doing business. At $4,000 a night, your fines don't mean anything. They comply. They simply then put it back on. And as a neighborhood, we have no remedy. As soon as he got the short-term rental violation, the time between when you issued the violation and when he came here, he made tens of thousands of dollars by continuing. And every time we called code after hours, they said there's a case already open and there's nothing else that we can do. So we may disagree on the irreparable harm because I don't know how you measure what he's done. And to be frank, I don't really believe that the remedies, if you tell him to stop, he is in the business of doing this. And if I have to come to every meeting for every one of his properties so you recognize that there are people behind this, real neighbors, that are harmed beyond your fines. I have 3 small children. We are next to 3 of these rentals. If he wanted to buy a hotel or build a hotel, he could have spent the same amount of money. He's trying to sell this property for $7 million. There is a hotel that I'm happy to offer your client that is for sale in the Mimo district that is $5 million. There is a reason that there is zoning, and I know that you are limited in what you can do. But this isn't a case where you have somebody that made a mistake and is sorry. And the harm to the neighborhood is irreparable. How do you replace the months that we've been dealing with this? He got the notice, and he continued every single weekend to have parties. Every single weekend. I ask if you can to find it. This is his first, because he knows the game. This is an LLC. All the other ones are in different LLCs. Same registered agent, same owner. I ask that you do the maximum, and I don't know if I can, and I don't mean to overrule the city, but like there has been a damage to the neighborhood. It also hurts the property owners that are long-term residents, because our taxes are actually impacted by this behavior. And I can point you to studies in Canada that show that this property was bought, it was built, and then immediately turned into short-term rental property. Because of the valuation differences in our property, what ends up happening is even the homesteaded properties, even though our property values, they rise, but so do our taxes. And if you intend to live in the neighborhood, I don't care how much my house is worth, because I just get taxed more and more and more as they flip these short-term rentals. So who's going to pay us for this fake commercial use that we then pay our residential taxes for? And I know I'm preaching to the choir, and you're limited in terms of what you can do, but I ask that when you look at a commercial operator, somebody who is really not, doesn't care because your fines aren't big enough, please consider the neighborhood. And I can talk to you about the nuisances, which have been many. They literally had buses drop people off, like passenger buses drop people off into the homes. We have them blocking driveways. I have a gentleman who's in his 90s, who's a retired dermatologist. He can only use the sidewalk because he's in a wheelchair. They block the sidewalks, and they consider it their parking, which they got a violation for. But this is, the disturbance is real. Sunday at 8 o'clock in the morning, I have house music blaring, which may be fun, but it's not something that we signed up for.
Right.
If I wanted to live in a commercial district, I would have. So to the extent that you can, I know you can only do certain things, because I believe this is his first violation on this one.
Yes.
I would say that, and I usually don't like going against it, but if you can do it, I would ask that you consider that the neighborhood has been harmed irreparably. I do not believe he will comply. He has submitted 2 false. When the police came 2 other times, he had his property managers lie and say they had a year-long lease. 2 different people.
Well, you were here last week when we had a hearing regarding another property in the same neighborhood. So we understand what you're going through. The only other question, and I'm sorry to interrupt.
I'm sorry to go on. It's
okay.
really terrible.
I have a question for the director.
Yes.
You mentioned something about a CU. How does this house have a CU?
So it cannot have
because
a
it's
CU.
not a T.
No, it cannot.
I'm sorry, sir.
It's not a T4.
So
it's a residential house.
I'm sorry, I misspoke.
Yeah, they cannot have a CU because it's T3. So I just wanted to make sure, correct that for the record, and I wanted to ask if there was such a thing.
I misspoke. As soon as they were able to get the building department to sign off that the house was occupancy. CO, I misspoke. I'm used to, it's running like a commercial property, so,
Okay.
Right. Thank you, Ms. Kalis. All right, so let me say this before, because I think you do need to hear from, and I think we have beyond preponderance of evidence, but I want to share this with you, in my conversation, full transparency. When I made this discussion, as part of our process, I need to create an incentive for respondents to say, hey, don't fight us. We have overwhelming evidence. But I need to create that incentive. That's why I did that. And I made it clear that ultimately, it is the board that renders that decision. So I wanted to put that on the table so that you all are aware.
The only thing I'd like to say is that as far as my opinion is concerned, I don't think we should send mixed messages now that with these Airbnbs, and that we're going to forgive one and not forgive the other, and no irreparable harm here and no fee there. I don't think that's fair. That is just my opinion. I don't know if the board they're entitled to their own opinion as well, but I don't think.
Right.
Well, let me say this.
I'm sorry. I was just going to answer what was raised by the chairwoman. In the past, when we've had testimony that there was either drug paraphernalia, or it was referred to us by the police, or parents testifying as to sexual activity going on by the pools, that's when we have asked for the irreparable harm, whereas when it's a first time, we wait until it's a repeat, and then we ask for the irreparable harm. At the end of the day, it is up to the board. I just wanted you to understand the process that we try and follow. When there's suspected criminal activity, we definitely go with the irreparable out of the box, okay?
Well, I think that irreparable, like she was saying, does send out a message, and yes, they can afford it. If they charge $4,700 a day, and if I were to live there, I wouldn't be a happy camper. They would be disrupting my quality of life. And if there's elderly people, we need to respect these property owners. They bought their house to live there a lifetime, not to be, have this kind of activity next to their home. You know how I feel about Airbnbs. I have them in my neighborhood, and I do not like them. So I am not in favor of them, and I'm not in favor either of providing or disregarding any kind of fine. I think that a hefty fine should apply, and if you're the first time, the second time will be greater, and so forth. They will continue doing it. They have the money. This is a business, and they don't care. So
Right.
do I have other comments?
Well, I think that council is going to speak.
Yes.
But having said that, as you know, if the residential property is being used for commercial use, you can go up to $1,000 per diem. We're requesting a guilty, 5 days to come into compliance, and $1,000 a day thereafter.
Okay.
So,
Madam City Attorney, is that the maximum fine that we can fine them?
For a first-time offender without being a repeat violation, yes.
Without making our case suspect before the 11th Judicial Circuit.
Okay. Counsel, I believe you wanted to say something?
I'm here echoing what the Code Enforcement Director said. We've discussed this with the property owner, and we've advised him on what we think he needs to do to come into compliance. I can't speak to personally what's been observed or not been observed, and I certainly didn't hear any evidence on drugs or sex at this point. So I just want to keep that on the record, and then I would go ahead and say my firm has been engaged to try and bring that into compliance, and I think the property owner will understand what the consequences are going forward. Certainly we will tell him.
Through the chair, I have two.
I think that, I'm sorry, I think the neighbor wanted to speak. I apologize, board member. I didn't, I was watching her when.
Yeah, and she was trying to.
And Ms. Hernandez, if she's going to speak again, and if she's going to make references to sex or drug use over there, after we've just told her that that's the way that you can go and get added penalties, I'm going to object for the record because that's not fair.
Understood.
So what I'd like to do is just reference you to the body cams of the police officers from the nights in which it was called. Once there was
it's not before them.
That's not in evidence here.
But we have experienced that, and I can send, so I don't, here's the thing. You can listen or you cannot, and don't if it puts this in jeopardy for irreparable harm fines. He's gonna come in compliance in 5 days because he knows the game. I will tell you, and I'm testifying, I think under oath right now, that we've had issues with what we think are prostitutes on the side. I don't know because I didn't ask them what they did, but it was very questionable. We've had issues with nudity in the pool with my children because there weren't enough bushes because my house abuts we're like right on the shared line, and you could see the pool. We've had, the police have been called because people were smoking marijuana, which I know may or may not be legal pretty soon, but it's not legal yet, down the street from people that were coming into that house. So I'm not saying it simply because of the case, and it is their decision about whether or not they get irreparable harm fines. You can do $1,000 a day, 5 days of compliance, but there is the ability to do irreparable harm fine right now, right? Correct. Because what is the maximum under the first 15?
The board has to find the gravity of the violation. The most that, and the board has in the past done a $5,000 irreparable harm, a $10,000, a $15,000. There are 3 factors that need to be, put forth. The gravity of the harm, whether or not the property owner has tried to bring it into compliance, and how much they've contributed towards the violation.
So I would just, the request is, don't consider, if that doesn't help, that doesn't consider, but if you say you have 5 days and it's $1,000 a day, you effectively will have zero fine because he will say he's in compliance for the months that our neighborhood has been dealing with this. And
But his statement is not, it's what the officer finds. It's not, they can say whatever they want to the officer. The officer conducts his own investigation into the short-term rental sites.
Yes.
If it's still on the site, the $1,000 a day starts.
Correct.
But I'm saying, so here's what my statement is. We don't know what's going to happen in 5 days. I would bet a lot that he will come into compliance like the other cases. If there's no irreparable harm fine, which I am asking for you guys to make, then there will be no consequence, no punishment for the misery that he's put our neighborhood through for the amount of time. This is his business. And so that's my only request of you. And I didn't realize that I needed to mention all of those things in my testimony, but it has been documented. That's why we called the police, because there were people who were walking and doing drugs. And I have kids that are like, they know, like, they're smoking pot, right? Like, I have kids that I'm trying to teach to not do things, and we've had just misery. So no fine and an ability to cure, or there's a fine, means no punishment to a commercial operator.
But ma'am, I know that you submitted some video to the inspector. Did you take video of that?
Of the people smoking pot? No, I don't know.
I collected body cam footage. Their admission at my first inspection, the initial inspection, was enough evidence for me to cite the violation. There have been some elderly neighbors that were not able to attend. They've been sending me movies, mostly of vehicles parked, activity. I haven't reviewed all of them because I have more than enough evidence to stick with the violation here. I couldn't cite those additional violations. I had a separate case for parking in the streets.
I know, but my question was very specific to what you observed. And it dealt with 3 questions: sex outside by the pool, drugs and drug paraphernalia, or any other type of criminally illegal activity.
From my perspective, no to all 3 questions. I did not witness that.
Okay, that's all I was asking.
Thank you.
Do we have any? Oath, I would like to say that I have. He only came for the one that was on body cam. Multiple other officers came there. So I appreciate it. I'm just letting you, I want you to understand the consequences of a commercial operator. If you don't fine him now, he will come into compliance, and there will be no consequence for what has happened to our neighborhood.
I understand, and Madam Chair, if I may indulge, a repeat violation the next time, let's assume that he comes into compliance and then in a month does it again, the fine goes up to $5,000.
If he doesn't comply, so you have to, so
it's from the date that the inspector cites them.
Okay.
Yes.
And so let's say that the inspector, they come into compliance, and next week they start again. And let's say it doesn't go to hearing until July. I'm just giving you an example. The fine is retroactive to next week when he started.
So what would the fine be for today then? Maybe I misunderstand.
We're asking for the maximum allowable of $1,000 a day, but under Florida statutes, we are required. What we are required to do is provide a reasonable time to come into compliance. It is the board's obligation to provide a reasonable period of time. And based on when they were cited, we're recommending 5 days. Many times, and I know you've been here and you were listening, we recommended 120 days on a case. So we're giving the shortest window. That's all we can do.
And the board is considering...
Well, I would like the board to make any comments. Keon?
Definitely would like to make
I would like to make a comment.
The first thing that I want to say is, do we have any more cases with this particular property?
Not at this time.
So it's an LLC.
Okay,
hold on.
no, he's asking the director. Sorry.
So, thank you, Ms. Kalis. Thank you.
Thank you.
So one of the issues, very smartly, that the operators do is they create an LLC per property.
That's fine.
So we cannot, it's very difficult for us, legal, to puncture the corporate veil.
Understood. That's the first question.
So you get it. If it was Jose Gonzalez or Joe Smith, multiple, then we could.
Well, he can close this one and open another one and
Could.
call it whatever,
Could.
and
So
so
that's-
on and so
So
on.
we
That's what they
do what we can with what we got.
So that's the first question. Second question is, I know the recommendation has been 5 days, but I believe we can go below 5 days. Am I correct on that?
You vote on that. Yes, you can.
Yeah,
You can-
I-
we are the board. We have.
No, we have a recommendation
Yes.
5 days, but I know we can go
So
lower
let
than
me
5
say
days.
that hypothetically, you say 1 day, and there was a list of 12 links.
Correct.
And council, who's very astute, says, per 16207, they haven't provided a reasonable time to comply.
Understood.
And now they take it to 11 judicial.
But
I'm
then
trying to make airtight cases for us, all of us here.
We agree. And then my third question would be, or my final question. Now, we've seen, Madam, what's her name again? I keep forgetting. her name.
Inspector Eric Encinosa.
No, I know your name. I'm talking about.
The residents.
Yeah. She was here before, I think a week ago, with her son, who was in the audience. I remember that. Yeah, she couldn't leave him home. And I just think that that's one of those situations where, I get it. We got to give some time frame, and I think that's where our hands are kind of tied at. We have to give time frame for compliance. But I also think that the situation, if this is something that's going to continue to happen, the irreparable fine really doesn't mean anything either. It just means they just keep paying it and keep paying it and keep paying it. But if it's $15,000 a pop, then I guess at some point you make a business decision and say $15,000 is just too much.
Well, there comes a point in time where, just like the city of Miami Beach recently went after 8 years, I think it was.
Correct.
They then went after that party house.
Correct.
And were able to shut it down. But again, you have to wait a certain period of time. And in the city of Miami, we're not going to wait 8 years. And we will do the necessary research on Sunbiz to show that it's the same individual, same registered agent, same type of entity, same type of activity, and the courts are not going to be sympathetic. But we're here, and I understand, look, I understand your frustration. Nobody wants to, council doesn't want to be sitting, living next to a party house. Nobody does. Everybody wants to have the quiet home that they, invested in.
They deserve.
And deserve. Having said that, we can do so much, but Tallahassee sets the rules.
Yes.
And we have to live by those rules.
So, just 30 seconds. I was a director of Miami Beach when we went after the party houses. And the ordinances, local ordinances, went to $15,000 a day. And what happened is they appealed the 11th Judicial and 3rd DCA, and the city lost. Because we exceeded, at the time I'm here now, cannot go beyond what the statutes reflect. So that's why I'm cautious in making sure that we stay within that framework.
Yeah, but that doesn't mean we can still decide.
Yes, you can.
Give them a irreparable harm fee.
That's correct.
Saying that, Christy, I think you needed
Yes.
to make a comment.
So one of the things that I wanted to bring to the public's attention is this is a corporation. This is not a homeowner. This is not someone's name. So they kind of lose a little bit of protection in this because they are in a residence. And this is a massive disturbance to our police and our fire. They are not able to get in. It is a constant, ongoing thing. So I am going to make a motion for, even though we know that this is a first offense for this particular owner, for a $10,000 irreparable harm charge and $1,000 a day thereafter.
How many
after 5 days?
To come in compliance, thank you.
If I may, if that's going to have a second, I'd like to make one comment, if this has a second.
Go ahead, Council.
If it has a second.
Well, not yet. I haven't said a second. Do you want to say a comment now?
Yes, if we're going to go with irreparable harm, then I'm going to have to, on behalf of my client, change the pleading to not guilty.
Well,
Because he reserves, that's okay.
That's fine.
And he reserves the ability to go and appeal to circuit
That's
court.
right. Right.
But that's why
we already.
That's what's at play.
So we have a first. Do we have a second? Motion dies. Do we have any further comments?
Here's where I think our hands are tied. One, we don't have a precedent of giving an irreparable harm on a first-time basis.
Oh, we do.
We have in the
We
past.
do.
Where?
Many times.
We do.
We have in the past.
When we have
We
when
have that right.
it's drug activity.
Well, correct,
right.
correct. I'm sorry.
And
There's a situation where we have done that with certain factors, and I'm not sure we have the factors today. I'm not sure.
We have
How many
more than the
sites are there
factors.
in?
No. What I'm saying is we have evidence of them doing short-term rentals. We have evidence of them maybe having a party or so, but we don't have the factors.
But the other short-term rentals that we've had don't necessarily
No.
have to have sex or
They-
pot or
no, but they
whatever.
do.
We've
But
ruled.
no,
And
but
why
they-
should
they do
residents
need it.
have to wait for that?
irreparable
They do need
harm
it.
based on
But-
that they're doing an Airbnb,
No.
which is illegal.
But they were
period.
not. But they were not. They were not first timers.
Yes, they
had
were.
not repeat- Well, I-
Absolutely. That you're
Okay,
totally
my fellow
incorrect.
board members,
Yes,
I'm just going to put it to
Totally
you like
incorrect.
this. We've heard that there are older people in this neighborhood. We've heard that their roads are blocked. I know what that's like personally. I have seen my own street, an ambulance not be able to get down, a fire truck not to be able to get down. Okay, when you've got older people, we cannot wait on them to die while somebody's doing their drugs and pot. I don't even care what they're doing inside the house, to be honest with you. I care that the streets are blocked.
I agree.
So that has no weight whatsoever. So I'm just saying, if this were your street, these were your neighbors, you would want a fire truck and an ambulance to be able to get down the street. So that is the reason I made a $10,000 irreparable harm charge, because we are very fortunate as a board that nobody died yet. So what are we going to do? Wait till somebody dies and then incite fees? Because I can tell you this, our fire and police, I've spoke with all of them. They're making more calls to Airbnbs than they are residents and citizens of the city of Miami, and I'm sick and tired of it. And we need to send a precedent that this has got to end, and it's going to end here with irreparable harm charges, because we have heard from our residents. She is absolutely 100% right. We must make sure that they are fined, that we send these investors, because that's what we're dealing with here, as an investor, a corporation. A corporation can die tomorrow and they'll come back up as another. They sell things. This is basically nothing more than a shell company, while we have actual residents that are being prevented from even owning a home because we are continuously allowing the Airbnbs to continue throughout the city.
Okay.
I would just tell you, if you do $15,000, I will second your motion. And the reason is, and I'm sorry for counsel that he believes his client, which that's his job to defend him. But I believe that the $10,000 is not enough. To me, $15,000 is not enough, because they have to deal with so many things. I have my daughter, and I don't want nothing like that next to them, even though I do have it, but it is like it is. So if you do $15,000, I will second your motion.
Do we have a motion? Your motion
I'll make a
died.
motion for $15,000, $1,000 a day, and give them 5 days to come into compliance.
I'll second.
Discussion?
Do you have a discussion?
Yes. Could I offer you less than 5 days, please? Because here's what's happening. And I know, Director, you're going to say 5 days is give them time. Give them 3 days.
I agree. Okay, so I'll rephrase the motion. $15,000 irreparable harm, 3 days to come into compliance, $1,000 a day thereafter.
I'll second that.
Board members, if I may, I have to then ask the clerk to please record a not guilty plea for this case. And I would like to put it out there just to repeat what the officer said, that he did not witness when he went out there, and there's been no evidence presented other than the testimony of the neighbor as to the elements that normally are required to go and take that step.
Well,
I just want to put that on the record.
What I suggest is, if the inspector did not see anything, why don't they bring the police in with the inspector? They should have been here.
Can I just ask
And
the
where's
city?
the body cam?
Is that a requirement, or is that what you customarily use to set that threshold? I want to clean that up.
Okay, so
Thank you for that.
the city, it is the director and my office's position that we make recommendations. But at the end of the day, we don't tie the hands of the board.
They can.
Many times they side with counsel for the petitioner. I'm not talking about short-term rentals or anything in particular. I'm just saying the board decides who and what they wish to believe and who and what they wish to determine. For example, in the Mount Zion case, they made the determination, we're going to go to 0, even though the director wanted 1,000 and then said 500. The board said 0, So we have internal policies as to where we feel this is what we're going to do. But it is always the board. Remember, the board comes to you as neighbors in the community with their own experiences and expertise. Some of them are attorneys, some of them are business people, some of them own buildings. So everybody comes with different, but they're the individuals that were appointed by the city commission to render these decisions.
Okay.
I understand. I think
Can I ask a question?
Go ahead.
Could I ask a question? Based on the motion that's been put forth, he goes and appeals this thing. What is the probability that it'll be overturned?
Well, I'm not going to say something like that, and I apologize, sir.
Because I really respect you coming here this evening, Ms. 𝐂𝐤𝐿, and presenting to us. You have 3 children at home, but you're taking time out of your schedule with your children, with your family, to come here this evening and talk to us passionately as you have. So we would like to penalize this operator, but we want to do it within the confines of the law.
We are.
And again,
I have a motion.
Could you please,
Go ahead.
if you don't mind, Chair, I apologize.
We are doing it within.
I don't think what I was asking was completely answered. Is the presence of drugs or sex a requirement per the code?
No.
Okay.
It is not.
So it is a customary standard, but not as council
It's
stated.
it's not even a standard. It is what the director, we meet in pre-agenda.
I just wanted that cleaned up.
And then we discuss it with the inspector and make a decision based on the discussions, what they feel comfortable, establishing based on the file. So that's how we do it.
I just wanted to make it clear so that if the board did choose to decide that there was irreparable harm, that it is not because there's some requirement that they're violating.
No, there's no requirement.
The way he stated
but it's
it,
understood that all those things come along when you rent an Airbnb.
Prove that, yes.
From the history that we have seen here today. So there's other Airbnbs that people are great and they're wonderful and you don't even know that they came and they left.
But those, for your
these
purposes,
mansions,
for your purposes, I just want to make sure it doesn't sound like you're violating some requirement because there is no presence maybe of drugs or sex. In this case, if you were to find irreparable harm, it's still okay.
It's okay.
It's your vote.
Thank you.
Through the chair.
I have a first?
Yeah, just one quick comment is, we know that this party house has been visited by the police. Police doesn't visit you property just because you have a rental, Airbnb rental. They visit you because you are beyond what a regular standard tenant does. And I would recommend her to get the police, public record request, get the videos. So when he goes to court, you can help him. And it's not, you come back to us and you send it to him. And we will record, we will put it here. Not a problem at all. And that way, when he go to court, we have all the proof that we need. Because sometimes people do not respect your house. And you have to fight for it. And if we can help you.
Thank you. I have a first and I have a second. All in favor?
Aye. All right, can
Thank you,
someone
counsel.
please repeat what it was? Because we went back and forth. Is it 3 days to come into compliance?
3 days.
15,000.
15.
3 days.
And $1,000 per diem.
$1,000 a day.
Thank you, and I was recorded as not guilty, right?
Right.
Yes.
Thank you very much, and I'm sorry it
Thank
took
you.
so long.
No problem.
Thank you.
Next
Calling
case, please.
Case, page 195. The address is 1737 North Bayshore Drive, Unit 400. Case number 68038. Address 1737 North Bayshore Drive, Unit 400, page 195.
Good afternoon, counsel. Please state your name and address.
Good afternoon, members of the board. Ben Fernandez, 200 South Biscayne Boulevard. Here on behalf of the owner as well as the restaurateur, bar restaurant.
I asked Santos, and I
Guilty or not guilty?
Not guilty.
Again, thank you. We'll let the city present its case. Good afternoon, Mr. Torres.
Good afternoon.
Okay, please state your name and official position for the record.
My name is Inspector Torres with the BTR Task Force.
Okay, and did you issue a citation to the property at 1737 North Bayshore Drive, number 400?
Yes, correct.
Okay, and did you provide me with your file in this case?
Correct.
And what we've marked as Exhibit A are your notes as well as the photographs and your research regarding BTR and CU, correct?
Correct.
And Exhibit B are the records of the property appraiser?
Correct.
And Exhibit C are the official notices and summonses required by Florida law, correct?
Correct.
Okay, and you cited the property for failure to obtain a warrant. Was that for outdoor seating?
Yes, initially it was CU. They were operating without a CU BTR and actually a warrant for the outdoor seating. They finally complied with the CU BTR, but they're still working on the outdoor seating permit.
And is that for the restaurant called 𝐂𝐢𝐭𝐲, K-L-A-W?
Correct.
Okay. And did you check the records to see if they have come into compliance?
Correct.
Have you?
I've been in communication with the lawyers from the...
No, Inspector. Did you check the records of the city to make a determination as to whether or not they've come into compliance?
Correct. I have checked in the zoning record, and there's no outdoor permit as per the CU and zoning, pretty much. Yes, correct.
Okay, so they are in violation.
Correct.
Okay. Okay, and when did you most recently check those records?
Correct.
No, when did you?
It was yesterday.
Okay, so they still don't have the necessary approvals by the city of Miami, correct?
Correct.
Okay. At this time, have you had any contact from the property owner or their counsel?
Yes, I have been in contact with the tenant, with the property owner, and with the lawyers. They're working with zoning and planning just to get a certificate. I was told today by the council that they don't actually need a warrant, but they need some kind of permit that is going to satisfy that outdoor seating.
Okay, and did you verify that with any of the, Did you verify what the lawyer said to you, the lawyer for the restaurant said to you with the director of zoning or the planning director?
No, I haven't.
Okay, so as of right now, your determination is that they need a warrant, correct?
Correct.
Okay, and did you discuss with them how much time to give them in order to come into compliance?
Correct. We spoke to the council, and we were conferring about 90 to 120 days just to finalize the permits that they need for the outdoor.
Okay, so at this time, we're requesting a guilty finding. Is it 90 or 120? Remember, council is pleading not guilty, so my question to you is 90 or 120?
I believe 90 days will be enough according to the
Counsel,
email.
didn't you plead guilty? You said guilty.
I did. I pled not guilty.
Oh, not guilty. I'm sorry. I didn't hear the not.
I mean, perhaps I can clarify. No, typically you plead guilty in order to get more time to comply. This is sort of a mixed bag because there really isn't. I think everyone's recognized that there was no need for a warrant in this case, and the whole enforcement action is based on the lack of a warrant. So
that's not true. It's not just the issue of the warrant. Your client was cited for various things, including a failure to obtain a warrant. You did not obtain a CU, business tax receipt, or a warrant for outdoor seating.
I believe some of those other things will fall into place after we have the seating issue resolved. So they're part and parcel.
It's up to you, counselor. Are you guilty or not guilty? Do you want 120 days? Do you want 90 days? You tell me. We're really trying to move forward here.
Understood. Well, again, we don't need the warrant, and we'll have an email here from the planning department confirming that we can get a certificate of appropriateness, amend it, because it's just a question of the number of seats that needs to be reconciled.
So you don't have a certificate of appropriateness, correct?
We have one, but it needs to be amended.
Okay.
This is a historic property. This is one of the most beautiful properties in the city of Miami.
I understand.
The Women's Club.
The bottom line is your client is in violation of the city's codes, and we're trying to determine in good faith how much time your client would need to come into compliance. But on the one hand, you're saying we're not guilty, and on the other hand, you're saying we need to amend a certificate of appropriateness. So you're operating without the appropriate approvals from the city.
Well, perhaps we don't have the business license for the outdoor seating. We recognize that. We're guilty with respect to that, but not with respect to the warrant, because the warrant isn't required. So that's why I say it's a mixed bag. How would you like me to plead guilty? We just need 90 days to comply.
Well, he's agreeing to give you 120, but...
We'll take it. We'll take it.
All right, so guilty, 120 days to come into compliance, $500 a day thereafter. And we wish to rebut when he finishes.
Right. Do I have a motion?
No, not yet. He has to put on his case.
I'm sorry.
You need to hear from counsel first. If you do that, we're going to go to 11th Judicial.
Sorry.
Excuse me, for clarity of record, did you plead guilty or not guilty? It changed. Guilty, thank you.
What else would you like to add, counsel?
I think I've said everything. We're ready to come back to you.
Any comments?
Motion.
Motion? Second?
Second.
All in favor?
Aye.
Okay. Thank you, Counselor.
Thank you.
Thank you.
Can we go over the motion, please, for clarity of record?
Guilty, 120, $500 a day thereafter until compliance is achieved.
Thank you. Calling our next case. Excuse me. Okay. It's page number 36, to be heard in Code Check agenda. They're here for several cases. The address is 25 Northeast 36th Street. Case number is 000-51286, page 36.
Good afternoon. Please state your name and address.
Hold on. Is this, wait. Because,
3601?
So we have 9 properties, Madam Chair. Page 36, page 40, page 44, page 48, page 52, page 56, page 60, page 64, and page 68, all owned by the same property owner?
That's correct, yeah.
And they're all parking lots, correct?
So they're all the same property, really.
Hold on a second. Name and address, please.
Thank you. Andres Rivera, office is at 1450 Brickell Avenue, here for the property owner. When the violations were issued, they were all separate folios, and that's why there's 9 separate violations. The folios have actually been unified since, so it's actually a single property now. I don't know if procedurally we can
Weren't
combine.
you here in front of us before regarding this and that they were separate lots?
It was a different, very similar, though. I don't know what it is, but I keep getting these.
He's the parking lot king.
Yes.
Please don't give me that nickname.
It was you who was doing the beginning, or it was somebody else on your
This is first appearance for this property. There was another, but you're right. There was another very similar one that had like 6 folios, and so we had a similar situation.
Real quick, so there's a unit title.
So we're pleading guilty to the open portions of the violation. There were some parts of the violation that have been complied, so those aren't an issue. But the parking portion, which is parking on an unapproved service, we're pleading guilty and requesting an extension.
Okay, are you pleading guilty to all of them, or we're going to go
and we have no objection to combining them since they are now one folio, so we can hear them all at once. That's
guilty
fine.
to 36, 40, 44, 48, 52, 56, 60, page 64, and page 68.
Correct, as to the parking component.
My God.
I'll call them all in so they can be on the record. Page 40, address 3681 North Miami Avenue, case number 000-51289, page 44, 3651 North Miami Avenue, case number 000-51283, page number 48, address 3701 North Miami Avenue, case number 000-51293, page 52, address 17 Northeast 36th Street, case number 000-51285, page 56, 3601 North Miami Avenue, case number 000-51284, Page 60, address 3620 Northeast Miami Court, case number 000-51290. Page 64, address 3630 Northeast Miami Court, the case number is 000-51292. Page 68, address is 3610 Northeast Miami Court, case number 000-51288.
Okay,
Thank you.
Madam Chair, if I may ask counsel to stipulate that the testimony and evidence presented in the first case will be adopted for all the others, so that way, because
Yes.
they're all basically the
Agreed.
same.
We have no objection to that. Yeah.
Okay, thank you, and that will help us.
Hi, Inspector.
Good
So-
evening.
Did he already plead guilty?
Yes, he did. But
Thank you.
synopsis.
Good evening, Board. Senior Co-Compliance Inspector 𝐂𝐤𝐚𝐦𝐢, after hours currently, but when I opened this case, I was on the Revenue Task Force. When I originally cited the property, there was several other violations, including a billboard permit that wasn't finalized, outside storage, failure to maintain, on top of parking on an unimproved and failure to obtain some kind of permit. I believe I issued the certificate of use of business tax receipt at the time because I believed that it was operating commercially. They have come into compliance with most of the violations. I understand that they're applying for an interim parking permit currently, and that takes a little bit of time. I spoke with the lawyer, and they said they needed, was it 30 days?
We think we'll have the interim parking shortly. Public Works has signed off. We're waiting on the zoning component, so hard to say, but hopefully, yeah, within 30 days, we should have that.
They requested 30 days. The case has been going on since.
But we're going to provide ample time because we part of the process.
60 days.
So I'm actually ready to say 90. I'd rather they comply within that period, so
that's fine.
We're absolutely done.
I have no objection. They've worked on trying to get this done. It just takes a little bit of time.
So for the record, I wanted to say, Inspector 𝐂𝐤𝐚𝐦𝐢, this is his second day with his promotion as Senior Co-Compliance Inspector.
Congratulations.
Yeah. No, number two, he really wanted counsel to say not guilty because he's ready to go to town. But these are the ones we prefer.
So, Counselor, you're asking for, you said 30 days, the director.
90 days would be fantastic, so we don't have to come back. We'll get this hopefully locked up sooner.
And so we're asking for a guilty, 90 days, $500 a day thereafter, as to each of the cases before you.
Any discussions? No? Do I motion?
A motion for 90 days, $500 apparently?
Yep.
Yes.
And per case. And 90 days to
Do I have a second?
compliance.
Second.
All in
For
favor?
all the cases.
Aye.
Aye.
90 days.
Thank you. I will not bring you any more parking
Good to
lots.
see
than
you.
that.
Calling next case.
Too late. We're putting your picture up beside a pocket.
Calling next case, page 130. The address is 500 Northeast 66th Street. The case number is 000-71233. Address is 500 Northeast 66th Street, and this is page 130.
Good afternoon. Please state your name and address.
Good afternoon. Diego Echeverry is 500 Northeast 66th Street.
Mr. Echeverri, guilty or not guilty?
Guilty due to ignorance.
Okay.
Thank you. We'll let the city present its case. We'll come back to you
All right,
for further comment.
Inspector, could you please introduce yourself and provide a brief synopsis since he did guilty?
Inspector Fabi Lubin, North Office, Code Compliance. Okay, so essentially we received a complaint from police regarding the property being used as a short-term rental. The initial inspection was actually done by Senior Inspector Comer, and they found the listings and all that online. But once she went ahead and posted the NOV, they did remove everything literally shortly after, so they complied with that immediately. However, there was also work that was done on the property without a permit. So there was interior remodeling, there were bars installed, as well as the window and door. So essentially, they advised that they recently purchased the property, but they purchased it with multiple problems, so to speak.
So what we're asking for on the short-term rental is a guilty, no fines, because, and this is for the benefit of our newer board members, once we have a guilty, if they're cited again in the future, we then treat them as a repeat violator, and the board has the opportunity to significantly increase the fines, and also that's when we request an irreparable unless there are other issues going on.
Well, he complied too within 30
Correct.
days.
Correct.
No, I
But I still want
understand.
the adjudication.
We want the adjudication
Right.
just to be, and then on the work without permit, how much time are you recommending?
Let's provide double that. I want them to.
120?
Yeah, no, she said 60, but we're going to go 180.
180.
180 days, sir. Okay, so 180 days, and after 180 days, 250 or
250.
$250 a day thereafter until compliance is achieved.
Mr. Echeverri, would you like to state anything or say anything regarding this matter?
Thank you.
Okay. Do I have any discussions?
Motion.
I would like to ask the code enforcement officer, have you checked this for Airbnb listings like today, last week? How many times have they been checked?
Well, I think the last time I checked was maybe like 2 weeks ago.
Okay, and nothing 2 weeks ago? So have you found Airbnb listings since the first time you cited them?
There hasn't been any activity regarding Airbnb at the property. I go by from time to time to see if there's any vehicles or, or the trash is overflowing, anything like that. Nothing like that.
And this property is owned by him personally? This is not a
Corporation.
corporation?
Yes.
A corporation.
It's a LLC.
So it's a
An LLC.
corporation. So this is still a corporation, so I just want to bring that to our attention.
Yeah, that's why it's 250
That
per
it's
diem.
bought for this, so we're
Do I-
essentially dealing with another corporation that's wanting to Airbnb a property. In my opinion, it's the same situation that we're in, so.
But let's give him credit. He did comply within 30 days. So he took off the listing and he complied. We get it.
And there
Any
are
other
no
further
neighbors
comments?
complaining.
No? Do I have a motion?
I will have a motion, find the property guilt, 180 days, 250, saying this doesn't live in there.
Do I have a second?
Second.
All in favor?
Aye.
I'm going to say nay.
Okay, and I just want to be clear on the record, Ms. Fincher, that it's a guilty, no fine at the present time on the short-term rental.
Correct.
Guilty and 180 days on the work without permit.
Yes,
Just a moment.
but you need to,
There's no way to split
She-
orders in co-chair.
She can't do a split
can't
order.
split.
Surely cannot.
Right, we've,
Then we
maybe in
need-
the future, yes, I'm working on it with IT. But for now, it has to be cumulative, so it'll be,
But if he opens up,
we need to do roll
I have to
call.
object. Wait,
yes, I
Wait.
understand.
wait. I just want the board to understand that guilty 180 days, 250 means that if he opens it up again tomorrow for a short-term rental, you have ruled that he has 180 days before he has to comply. And my position is, it's guilty as to the short-term rental, and we're going to comply it tomorrow. But as to the work without a permit, I'm willing. So my attitude, I'm sorry, Robert.
No,
Okay,
I
I have
understand.
a question for both of you.
Yes,
In our document, it say illegal rental, complying December 27. We're in April. Use not allowed in zoning district zone, it says December 27. So we're in April. Why do you want to do something for,
We didn't have quorum.
no, but here
No,
it says
he
it.
complied already
Complying.
a month after he got cited. He got cited
so
in,
let me.
But we
November
want to get
30th.
it guilty so that we can bring it back as a repeat.
but he already said he was guilty. So why you say guilty again?
No, the concern from
It has to
legal,
be an adjudication by the board of a guilty in order to treat him as a repeat violator in the
the
future.
concern from legal is that, I don't want to give them ammunition, but if they come back and do short-term vacation rental, that we don't have the ability to do a split order, right? Other places do, we don't. The database doesn't allow. It would be a immediate compliance for the use, right? Short-term vacation rental, and 180 days for the construction work without permits. We don't have that ability. Her concern, validly, is that if we put the order, we put it as one, they come back and do it a week from now, and we can't technically.
Yeah, but they can do it with 90 days. They can do it with 60 days. They can do it with 30 days.
So-
They can
That's
do
why
it
I
whatever
wanted-
days.
but that's why I wanted
you know,
a split
I mean,
order.
180 days is a lot.
So this discussion item. So go ahead and put it for 30 and give them an EOT.
Through the chair, so we go back to the same point. If you inspectors know that you cannot do a split order, why don't you do separately? Why don't you do one short-term rental and then you do another one for, because you guys put us in the same position every time we have a meeting. We can't do a split order. What we can do when you inspectors are the one doing the inspections?
So we're working on it with IT, and to your point, it means doubling, because they're here, you can ask them, doubling everything, and that's, we need to do it. A double case, it means sending all the certified notices, doubled, everything adds up. So I'm the sentinel of the department. I need to look at all my costs, overtime, expenditures, etc. So I need to look at the big picture.
Well,
You make a good point. I'm working on it.
We can fix what is not in our hand. We can just vote and what we have to vote.
Then,
and that's it.
then my
I do it 30
position
days.
is forget about adjudicating since he's complied, she closed the file, just deal with the work without, and then we'll come back to you if he does another short-term rental. Unfortunately, we won't be able to treat him as a repeat.
So my recommendation is different. I'll say do 30 days. Let him get an extension of time. When he gets the EOT, we'll give him another 6 months. So
then.
after 30 days, if he does short-term vacation rental, it comes back as a repeat violation.
Can I,
30 days to comply, not 180.
Well, we had a motion, we had a first and a second, so somebody needs to withdraw
It's
their
already
motion.
been voted on.
No.
I'll withdraw the second.
Excuse me?
I'll withdraw. I was the second.
You withdraw your motion? Who, the first one?
It
He was the second. I voted nay because of this
Right, I know you
situation.
voted nay.
It
Who
was moved by Bettencourt.
It
Do
was
you
my
want to
motion.
withdraw your motion?
No.
No? Okay, so the
withdrawn
motion,
second, motion fails.
Ma'am,
Yes, sir. Hold on,
explain
Mr.
to
Chief.
him that he can't speak while they're speaking amongst themselves.
give me 1 second.
My question is for our attorney. I don't, this opens us up to, and I understand, let me ask you this question. Can we require the inspector to make a visit within,
She just went 2 weeks ago.
I know, but as a part
He
of the
complied in
motion.
December.
I know, but see, we have, the issue that we have here in the city, the legal makes a great point. If anybody's paying attention, who's in that illegal business, they would have noted what she said.
That's why they're saying to give less days.
Right,
because-
so, but I also want to strengthen it, not just with less days, but also make it a requirement that this inspector goes by there to verify that that is not taking place within that time frame. Is that something I can propose as
So
part
I
of the
think,
motion?
yes, that is something that you can propose. I think based on what we've heard, it seems like you have two reasonable options, which is to give very little time and provide him with the information necessary to request an extension almost immediately to protect yourself from a repeat use of an Airbnb.
But it would be, sorry.
No, go ahead.
Okay, I'm sorry. I just feel that the cleanest way, because if he asks for an extension, it's for the entirety of the finding of the board. So my legal position would be allow the compliance to stand. If she catches him doing a short-term rental in 5 days, bring it back to the board as soon as possible. I always try and prioritize short-term rentals anyway, and continue with the guilty 180 days, $250 a day, until compliance is achieved on the work without permit.
I have a question for the director, which no one has asked. Does he have an application? Has he started an application for the work without a permit? No one has asked that.
Well, and I also have a question for the gentleman. Does he have a lease on this property now? A long-term rental lease? Or who's living in the property now?
Sí, tenemos long tenant.
Yes, they have a long-term resident.
Okay.
Nothing has been submitted to the city to that effect.
Okay. Nothing has been submitted to the city for a
Do you
long
have evidence of a long-term rental, Inspector?
Not that I'm aware of.
Nothing has been provided, there's nothing in the file. So, and our position is, Board Member Tasker,
Incomplete, yeah.
Yes, I'm sorry.
What a lot of these individuals with short-term rentals is they think that, not that this gentleman would, but they think they're being smart by saying, oh, we're going to do a 30-day or a year, but then the option is to terminate earlier.
Right.
Like you can do a year, but there's provisions in there that they can terminate after 4 days if the person wants to be 4 days.
Of course. So my question would be, if we've gotten that, then our inspector can actually go out and check after 7 days, 10 days, just, she can spot inspect when she's in the neighborhood. That's what I would recommend that we do.
So the or was to give more time, but require frequent monitoring.
Correct.
Well, right. I'm going to tell you legal's position. We're the team that defends these cases. Just leave the short-term rental as complied as what the officer did. Continue to monitor and do the guilty 180 days, $250 a day thereafter. And I know that the property owner is dying to address the board, but that's my recommendation. It's up to you whether you want to include them all or not.
Well, I think he has a right to say something and to speak.
No, I understand. I'm just saying that the gentleman...
Echeverría, would you like to say something, Echeverría?
Okay. They are not in the business for Airbnb. They were approached by somebody to rent it for a short term, and that's what they did, but they're no longer doing that, and they have a long-term tenant at the moment. They promise not to do any more short term.
Thank you. Do we have a motion? Oh, Inspector, I'm sorry. I can't hear you unless you speak in the mic.
Senior
Thank
Inspector
you.
Ebony Cormer, North District. May I request that he provides the lease agreement?
Copy of lease?
Yeah.
Ask him if he can provide the city with a copy of the lease, or the inspector, actually.
They will provide.
Okay, before we finish here, he needs to speak to the code enforcement officer so they can see how they can get that lease to her. Any further discussions? No?
I'll make
Do I have a motion?
I'll make a motion for him to give him 180 days. He supplies the lease to the city attorney or the city, and anytime he has thereafter.
The inspector to go by the property?
Yes,
and make sure?
yes. The inspector will go by the property at spot to check the lease, and it's $250 a day?
Okay, can I rephrase your motion?
Yes, sure.
Okay, the motion is guilty and 180 days for the work without a permit and $250 a day thereafter. Separately, she's complied to short-term rental. You're directing her to keep on top of it in the event they do another short-term rental, and she bring it immediately back to you. Is that what you were trying to say?
Yes, plus the lease agreement. He's agreed to supply us with the lease agreement. So the motion as is, as she stated, I'll make the first.
Do I have a second?
Second.
All in favor?
Aye.
Thank you. Tell him he has 180 days, $250 after. Speak to the inspector if he needs to request additional time after the 180. Next case, please. Thank you.
Calling page 90. Case, the address is 1020 Southwest 4th Avenue. Case number 000-74958. Page 90. Address 1020 Southwest 4th Avenue.
Good evening. Please state your name and address.
Hi, my name is Jonathan. I'm the property manager. This is the owner, Emilio Lopez. The property address is 1020 Southwest 4th Avenue.
My apologies, Melanie. What page?
90.
Thank
Page 90.
I'm sorry, the gentleman is who?
The property owner, Emilio Lopez.
And you are?
His property manager.
Oh, his
Take care
property
of all
manager.
Okay, Melanie, could you read out the address? Because I have two files labeled 90.
It's 89, I'm sorry, just a moment. The address for this case is 1020 Southwest 4th Avenue. Case
Thank
number,
you.
Guilty or not guilty?
Guilty.
We'll let the city present its case. We'll come back to you.
Inspector, please provide your name and give a brief synopsis. He did plead guilty, correct?
Yes.
𝐂𝐢𝐭𝐻, Code Compliance, BCU. Yes, they got cited for no CUBTR. They tried to apply. Again, they have an issue with the 40 and 50 years recertification, so that's why they're here to request more time.
Wait, is this a to be heard?
Yes, you have the file?
Yes, it's
No,
a
I
to be
know.
heard.
But she said they're requesting more time.
So they
They're
need
requesting
additional
time.
because
They come here to request time because they pled guilty.
they're in the midst of their 40, 50-year certification.
Yes.
Would like to ask, where are you in that process?
It's been submitted already. We just got 3 comments back from the city. We're waiting, actually tomorrow it's supposed to be submitted from the company Allied, but this was done, I would say, over a month ago. And we recently got the comments back and we didn't notice that there was comments on there. We thought it was completely submitted. That's the information we got from Allied.
Okay, but when were you cited?
We didn't know that we got cited for the 40, 50 year. We come to find out when we applied for the CU.
No, you got cited for no CU, no BTR. When did you get cited?
January 8th was the first citation.
You're talking about this citation?
Correct.
Okay, but they're asking about the 40-year certification.
No, I was
The
asking.
40 year we didn't find out until we were applying for the CU.
Okay, so now you just found out about it?
For the 40 year.
Because you had this violation?
Correct. When we applied for the CEO,
They told you you need
they
the
told us we
40
can't
years.
because there's a violation on the 40 year.
And we're still
Oh, you need time.
for the CO to be, they will not accept the CO until the 40
I
years.
know. That's the holdback to everything.
Okay, board members, they have had a notice of violation since September 13th, 2022.
Did you own that property at that time?
Yes, he did.
You didn't know that you were cited?
I had no idea.
Where did the notice go to?
It went to the address, as you know, under Florida statutes, chapter 162, our responsibility is to mail and post. We posted the property, we mailed it, certified mail. If they don't accept mail, which a lot of property owners don't accept mail from the city, it is not our responsibility, rather it's theirs. From my perspective, I would not give them more than 15 days, but I defer to the director.
Okay, but our documents say January 4th,
Correct.
2024. Does mean it was never posted in the system?
No, that's,
Okay.
go ahead and elaborate.
This is a handwritten notice, basically the previous inspectors that was doing the BCU, and I just follow up with this violation. So basically, I opened a violation, an NOV, so to make it, accurate in the system. So basically that, but I'm only telling you that they're aware of the violation since 2022.
So you understand?
So they've had
it's not really a violation like a written, it's a handwritten notice of violation, but it's not a record, it's not recorded in the system.
So nothing we can
Well,
So they've had more than enough time to come in and pull their CU BTR.
But again,
And
they've
to
been operating with us since 2022. So
Right.
basically, they know legally they need to get a certificate of use.
That's what I'm saying.
Okay.
So, to sit here and now say, oh, we don't have the 40/50, as far as I'm concerned, too little, too late.
here's the concern, that they're diligently going through their 40-year certification, and they're in a catch-22. They're not going to be able to get that CU BTR until that is completed. So I would,
The building doesn't look like it's falling apart.
right. So they should get it. I will
The
amend.
inspection's done. There's just 3 comments that need to be changed.
So my recommendation is slightly different, that I would provide at least 30 days.
30 days so they can come back?
Say that again?
30 days so they can come back.
30 days.
We're going to put them on the clocks.
Excuse me. It's going to be submitted tomorrow, but unfortunately, the city's not going to give us an approval within 30 days.
Yeah, we know that.
Right.
That's why he just.
This is why I'm asking for more time than legal.
Yeah.
The reason I'm asking is because you're not going to finish your 40-year certification anytime soon.
It's done.
And then you have
Done.
90 days.
No.
It's
It's only 3 comments that we're
He's almost there.
requesting to change.
It's the city of Miami. So you might be dreaming, and believe
No,
me,
no, I'm
a
saying
lot
our
of us
end will be-
dream
will
that
be
we can
submitted,
fix something
but-
in the city in 30 days, but we have to put our foot in the ground
Okay.
and realize.
Any further discussions? Is there something else you'd like to say? No? Do I have a motion?
I'll make a motion, 90 days.
I'll second.
How much per diem?
And we're asking for $1,000 thereafter a day until compliance is achieved.
$1,000
No,
a
he's
day.
not a repeat.
So why are we asking for $1,000?
Because the statute and our code allows us to go up to 1,000, and because they've
commercial
known since
property.
2022 that they needed to do the CUBTR and didn't do it.
I think
we
it's a
never
lot.
got that
I think
notice,
$1,000 is a lot. I think
Me
it's
too.
500.
I think it's too high.
They're working on this. It's not like they're not.
Okay, so I'll
I have
amend the
emails
motion.
and everything submitted and everything.
Right. So
I'll amend the motion. So 90 days, $500 a day there.
do I have a second?
I'll
Let's
second
get
that.
it done.
All in favor?
Aye.
Thank you.
Thank you so much.
Take care. Bye-bye. Good luck.
Calling page number 98. The address is 6923 West Flagler Street. Case number 000-71990.
96?
Page 98.
Oh, 98. Good afternoon. Please state your name and address.
Nate Ojeda, 6923 West Flagler.
Guilty or not guilty?
Guilty.
Thank you, Mr. Ojeda. We'll let the city present its case. We'll come back to you for further comments.
Wait.
Go ahead and provide a synopsis. They pled guilty.
Good afternoon.
Inspector Torres with the BTR Task Force.
Go ahead, provide your synopsis.
Okay, doing a randomly check for BTR and certificate of use. This unit 6923 was operating without a CU and a BTR. I cite them, and they'll be working on getting the permits for the 6923.
How many days are you recommending?
90 days.
Just a quick question. Where are you in the CU
Sorry?
application? How far are you?
They're already in the process of already getting their CO for a music studio. The issue was I had my assistant supposedly being updated with this, but I wasn't unaware that they took so long even after they got the violation. But they are working on this permit.
No, okay. No, then I guess you're changing the use, right? To what it was, to it is now? That's what you are stuck on it?
Correct.
Do I have any further discussions? I couldn't hear you.
Did he state his name for the record?
Yes, he did.
Okay, sorry.
Mr. Ojeda.
I apologize.
Nate Ojeda.
Okay,
Ojeda,
sorry.
he
I just
said
wanted to make sure we got it.
Okay. So he said he went and said he's guilty. They recommended 90 days. So do we have a
Okay.
motion?
I move for 90 days. It's a commercial, so 500
Yes.
per day after.
Do I have a second?
Second.
All in favor?
Aye.
Aye. Thank you. You have 90 days.
Good luck.
I think there's another.
Okay, what was what was
90
it?
days.
92.
Oh, there's two
Yeah, excuse
properties.
me. From the same owner, there's a 6903.
What
Excuse
page
me.
is that?
It's also, I don't know the page number, but 6903 West
Hold
Flagler.
on.
Hold on.
We have to let the
Let
clerk-
Melanie call it.
6903.
Is that
Okay, page 120. Case number is 000-71881. The address is 6903 West Flagler Street.
Correct.
Please state your name again and address.
Yes, Nate Ojeda, address 6903 West Flagler Street.
Okay. Guilty or not guilty?
Guilty.
Thank you.
okay? Brief
Inspector
synopsis, same as before.
Yeah, Inspector Torres with the BTR Task Force. Again, I was doing a random check for CU and BTR. Unit 6903, they were operating out of the scope. They had only a CU and a BTR for office, not for pharmacy. And after checking the inside of the property, I find out that they pretty much knocked down a wall. And they're operating from 6903 and 6905. So property owners, they're working on the building permit just to legalize the work that was
Yeah,
performed.
but we don't have that in our.
Did they have a permit to knock down the wall?
No, they didn't.
Yeah, no, but we don't have this
But
on our booklet.
That's not before them.
This
Right.
is not.
However, at that point in time, I cited only for CU and BTR. Then I realized that. So it's not on this particular case
We
that
can't
I
consider
work
that
without
right now.
permit. Correct.
Okay, thank
So they
you.
need to pretty much finalize the building permit just so they can obtain the CEU and the
I saw
BTR.
also that he's delinquent payment for the business tax receipt,
Right, for the one that they currently had at that time.
so he
That
hasn't
was for
paid
the
for
office.
that.
Yeah, they did pay.
Oh, they did pay. So he complied with that one?
Yes,
Did you
for that
say?
one, yes.
Okay, so 1808 has been complied.
Correct.
Okay, so we're talking about 1809 and 2110 as far as references for a violation.
Right.
Okay, great. Thank you for clarifying.
And for the record, I will assist separately on the other permit. We'll release any holds from code, so you can proceed. Okay?
Okay, how much time do you recommend,
I'm,
Inspector?
since they need to finalize the permit for, and we have the general contractor here, I'm recommending 120 days so they can finalize the permit. And then between the building permit and the CEU and the BTR, new applications for.
Great, thank you. Mr. Ojeda, any further comments? Are you okay with that?
Yes, I do again apologize. I had my assistant, I wasn't aware, but I did communicate myself immediately with the tenant, and he did get on the proper contractor, and they're working it immediately. So again, I'm guilty and apologize, and I appreciate
Thank you.
your
The
consideration.
time. Yeah, so we're asking for guilty, 120 days,
$500.
and then $500 a day thereafter until compliance is achieved.
Any further discussions? Motion, please?
I'll make the motion as stated.
Okay, do I have a second?
Second.
All in favor?
Aye.
Thank you.
Thank you.
Have a good day, good luck.
Can I have you sign in for the last one?
Next case.
Thank you. Oh, I'm sorry.
We are going fast. You see some emerging stuff. Okay.
What's next? Thank you. Calling page number 106. The address is 474 Northeast 50th Terrace. Case number 000-63687, page 106. Address 474 Northeast 50th Terrace.
Good afternoon. Please state your name and address.
Joandra Lopez Garcia, 3160 Northwest 32nd Street.
Thank you. Guilty or not guilty?
Well, I'm not very familiar with the case. I have to admit, the person that was supposed to come here had to travel last minute to his country because he had a person who died in his family. And last month they asked me if I could come in today. So I'm not very familiar with this.
Are you aware of your violations and what they are?
I'm not the property owner.
Oh, you're not the property owner. Does she have a proper
I'm representing
power
the
of
property
attorney?
owner. I have the power of attorney, but I'm not very familiar with the case, I have to admit.
She does have a power of attorney, but and I'll be honest, she has one, but she mentioned to me that the owner had already spoken with the director.
So did he plead guilty or not?
Well, he's supposed to, but, I can't, I have to yield up to her how she wants to proceed.
All right, so we're going to proceed as though she pled not guilty because, we have a lot of files.
No, I'm just here to ask for an extension to comply. That's it.
All right, did you give your
Speak
name
into
and
the
address?
microphone because we can't hear you.
I'm sorry.
It's okay.
I'm just here to ask for an extension to comply.
No.
So it's
We're
not
trying
an
a
extension
case.
of time.
There's no extension.
It's an adjudication, and you were supposed to plead guilty, but that's okay. We'll go.
I'm
It's our process.
No, we're not.
We can't do that to you.
Yeah.
It's up to you.
I'm sorry.
You have to state, ma'am, I understand.
It's my
but
first
at the end
time
of the
here.
day, I understand. But at
So-
the end of the day, you're supposed to know why you're here.
I know.
So, okay, you already state your name and address, correct?
Yes.
Okay, Inspector, state your name and official position.
Senior Inspector Ebony Comer, North Office.
Okay, did you issue a citation to the property at 474 Northeast 50th Terrace?
Yes.
Okay, and did you provide me with your... Okay, I'm sorry. Did you issue a citation to the property at 474 Northeast 50th Terrace?
Yes, I did.
Okay, and did you provide me with your file in this case?
Yes.
And what we've marked as Exhibit A are your record search on IBIZ as well, or iBuild for the city, as well as the microfilm documents regarding this property and your photographs of the violations?
That's correct.
Okay, and what we've marked as Exhibit B are the records of the property appraiser, correct?
That's correct.
And what we've marked as Exhibit C are the official notices and summonses required by Florida law, correct?
That's correct.
And you cited the property owner for work performed without a permit or a permit which was not finalized, and that was for driveway pavers that extend illegally in the front of the property, correct?
That's correct, and there's more.
Correct. We're going to put the NOV on the screen because originally it was only for pavers, but it does say in the body, right there, including garage conversion, enclosure, and concrete deck.
Okay.
So it's in the-
So they also did a garage conversion as well as the concrete pavers, correct?
That's correct.
And you cited them in September 18th, 2023.
That's correct.
Did they contact you in any time?
I have not received any contact from the owner. This is my first communication today concerning this property.
Okay, and in addition to no contact by the property owner, did you check the records to see if they had filed an application with the city?
It's blank. There's no application with the city.
So they've not done anything since you cited them in September of last year, correct?
That's correct.
Okay, and at the present time, the property owner is not here, and the individual who is here was explaining to the chair that she doesn't know, that she was just asked to be here, correct?
That's correct.
Okay, and at this time...
That's not exactly what I said. I said I wasn't familiar with the case, just in case you wanted to ask me. I mean, I'm not familiar with this.
Right, she's not familiar with the process of being guilty,
Just so you
not
know that I
guilty.
don't really know what I'm doing. This is my first time here. I'm not very familiar with this.
Just to add, there's a makeshift door that's built on the lawn, and there's no permit for it.
Okay. And those are the pavers, correct?
That's the door that's built in the lawn area with no permits.
Okay. And at the present time, are you recommending any amount of time in order for the property owner to come into compliance?
So I do have a recommendation because I did speak with someone on behalf of the owner, and based on the pavers would have been very simple, but the garage conversion is going to take a little bit longer. So we're recommending a fine, 180 days to come into compliance, and a fine of 250 days for every day thereafter.
Well, it's 150 because
It's homesteaded.
Is it homesteaded?
Yes, sir. Yes.
Okay, 150 it is then.
Are you okay with 180 days? Okay, they're giving you 180 days for you to start the process of the city to fill out the application, get an architect, whatever you need to do for the garage enclosure.
Okay.
You haven't done anything in 7 months, or the owner hasn't done anything in 7 months. They have not tried to fill out an application, submitted it to the city, nothing's been done. So that doesn't look very favorable on you if you come back and there's nothing done in 180 days. I would not recommend 180 days, because if they haven't done anything in 7 months, they're not going to do much in 180 days. That is my
But get a
opinion.
bunch of extensions from the city.
Right. I would give them like 30 days, make sure that within 30 days, they start with the process of the application, and then they can come and explain to us as we go. We give them more time. But at 7 months, we don't see that they've done anything. They're pretty much sitting on this.
Right. And Madam Chair, if I may, for residential properties, the board can assess up to $250 a day for first-time offense.
But this is homesteaded.
I understand.
And,
Well, that's not what this says.
and let's be honest, at least they got somebody to show up and have a power of attorney. Most people don't even show up.
$250 per diem for residential property? Yeah, but we were always told it was $150 for
Yep.
homestead. Okay. Well,
It's
all right.
homestead.
Okay. Well, good to
I
know.
would make a motion for 60 days, to give her 60 days. That way they have an opportunity to find
250?
someone, find
Per
250
diem?
a day thereafter.
Do I have a second? All in favor?
Aye.
Thank you for
You're
explaining
welcome.
that.
Make sure you start
Please
the process.
make sure you get in touch with the inspector. You need to speak
wait.
to her now, because you can get into further problems. Thank you.
Calling
Next
page
case.
number 186, page number 186, address 1850, Northwest 24th Court, case number 000-60349, Page 186.
Good afternoon.
Good evening.
Please state your name and address.
My name is Wilfredo Fernandez. My address is 1850 Northwest 24 Court.
Guilty or not guilty?
I'm not sure.
Well, you have to be, one or the other.
But I don't know why you have still.
Well, do you know why you were fined?
A little bit, I don't know.
Okay, what do you understand that you were fined for?
I have different things. I removed okay. I bought the property a few months ago, maybe 1 year ago. I work in the city of Miami. I don't have a lot of money.
No, I know, but hold on one second.
Okay.
Let's go one step at a time.
Yeah,
Well, you
yeah.
can talk to me later more about not having a lot of money and all
I do
that.
repay for...
I understand, but I need to know if you're guilty or not guilty. Did you have illegal units? Did you have work performed without a permit? Yes?
I said no.
You never had illegal units? Never? No.
What is your name, sir? What is your name?
Already, Wilfredo Fernandez.
Wilfredo Fernandez Izquierdo, right? Okay. We're going to assume he's pled not guilty so that we can go
He's
forward.
pleading not guilty.
Yeah.
Pretty much.
Okay, please state your name and official position.
Andrea Aquino, Court Compliance Central Office.
Okay. And on August 21st, 2023, did you cite the property owner of 1850 Northwest 24th Court?
Yes, I did.
And did you cite them for work without a permit, illegal units, mobile home parking, travel trailer parking?
Yes, I did.
Okay. And did you provide me with your file in this case?
Yes, I did.
And what we've marked as Exhibit A are the photographs that you have as well as the
Work performed without a permit.
as well as the documents from the building department and microfilm.
Yes, I did.
Okay, and this is a two-story house, correct?
Yes.
Okay, and what we've marked as Exhibit B are the records from the property appraiser, correct?
Correct.
And this is primary zone, the primary land use is multifamily?
Yes.
And you just provided me today with additional pictures of additional work that was done on the property, correct?
Correct.
And the work that you provided me photographs with today are those recent work that was done without a permit?
Yes.
And could you take a look at the photographs that you provided me for and tell me and tell the board what those photographs depict before I send it down for them to review? Go back to your thing.
Go back in the picture. Go back in the picture so they can see it. It's like that one, where is the garbage can? The
garage.
That space is what I think is the legal unit. This is the door over here, the door and the window.
No, he has a parking space right in front of it.
That one. And this was a proactive inspection. What I catch my eye, it was the mobile home. But when I was there was building. I found it in the act.
They were building, they were doing work?
They was building all the construction material and everything.
Inspector.
It's nothing that I don't see it.
Inspector.
I catch him in the act.
Inspector.
Yes.
You say they're building that. I need you to say what they were building.
They was building the facade or the illegal unit or the illegal addition.
Okay. That was another illegal addition?
No, that was the one.
Okay, and what is that picture demonstrating?
There is all the trash that was around the house. I took a picture.
Construction
he
material.
He was building illegal laundry.
Okay.
It's there.
And you pointed to construction materials in one of the photographs?
Yes.
Okay. And did you give me back the photograph so I can pass it down? Unless you all are seeing
Yeah,
it
we've
on
seen
the... Okay.
We've seen it here.
And these photographs that you were describing with the door on the side, what I can say on the side swale area, or the setback, are those photographs being, that's not what that is.
No.
Are these, did you submit these so that they could put them up on the screen?
I put it in the file. I download in the file those.
Okay, is this a single-family home or is this a duplex?
No, it's a duplex. It was converted legally.
So one on the bottom and one on the top?
Yes.
Okay, so what we're discussing is that side unit there that they've enclosed and they have fixed as the illegal unit, because it says here illegal units, more than one.
Yes, but I haven't been inside. I need access inside.
Well, there's a
And
side
he denied access.
We went and inspect the property. I went with my supervisor, but we didn't go inside now.
Okay. Did you ask for permission to go inside?
I asked, but it was like a conflict, when we went. I tried not to go inside because, he was very aggressive at the beginning. Now he come down and...
Okay, so you asked for access. He became aggressive. You backed away.
Yeah, I went in that time with my supervisor. I wasn't alone. Okay. So we just, to maintain, we say, okay, we just ask in court to be having access to the property.
This door that I'm pointing to,
Yes.
is this recent?
Yes.
And how recent is it?
After the violation started, that we went and visited the property.
So after you had provided notice to the property owner that he was doing illegal work, he continued, even though you advised him, and you speak Spanish, correct?
Yes.
And the property owner speaks Spanish, correct?
Yes.
And you spoke to him in his native language?
Yes.
And you explained to him what he was doing illegally?
Yes.
Okay. And after you explained to him that he could not do what he was doing, he went ahead and did additional illegal work. Is that correct?
Yes.
Okay.
He applied for the permit. The permit are being reviewed.
I'm requesting a guilty finding, 10 days to come into compliance, since he had more than enough time since August of last year when asked by the inspector. Instead of admitting or providing access, if he felt that he had done nothing wrong and had no money, he would have allowed her to inspect. Instead, he became aggressive, and then after he received notice of the violation, continued to do more illegal work. This is an individual who does not want to comply with our codes. We're requesting a guilty finding. Legal is requesting 10 days, $500 a day thereafter until compliance is achieved.
I have a question. There's a photograph of it's like a hall alleyway, or it's not an alleyway, it's a side of the house that you could see the white fence. There's a door there. There's another door here that no one has talked about.
And it's high.
Plus you have electrical.
There's not even a step there.
You have electrical.
They opened that hole there and they opened the door, so that's probably another unit. So you need to make sure, because there is a door on the side.
Madam Chairwoman, can we let him speak and let's ask him about these doors?
So let me explain, the process. So, hold on. No, hold on. My turn now. You'll have a chance to speak. So part of our process when we cite, right, if he denies access, we can now adjudicate, and part of the compliance is requiring access, right? And along with the permit, so he's going to have to allow. And if that wouldn't happen, we could always get an administrative warrant. But we're not there. We have sufficient, I believe, clear and convincing evidence that this has happened, and there are illegal units. So part of your recommendation, and in order to have compliance, is for allow our interior inspection.
I have another question, if I may ask the owner, Mr. Fernandez. Mr. Fernandez, do you live in the property?
No.
You do not? Okay. Because you're claiming, bueno, they're putting here the address the same. What else would you like to say?
I work with the city of Miami. I did the roof permits before the
inspector.
The inspection. Okay. That's allow 20,000 with permits, with inspection, with everything. That's maybe she see material because in between. The final inspection was after she stayed in the
So you
property.
finished your roof inspection, that's closed, you passed it?
Yes, already.
In 2016?
Yeah, no. Now.
No?
Yeah, no.
2016?
No.
Can you put the address up?
No, I have here.
All right.
Okay,
2024.
You can show it to me.
Okay.
Give him a second to look.
I have here.
Right. Oh, it
It's
is.
the last one.
Okay, so he has a roofing?
Yes.
It's pre-screen.
This is the old
Final, all inspections final.
This is the old property, like 90% in Miami. I have submit new permits in Miami right now, the inspection no, to continue to put the complaint about the property. This is the old property. I do, step by step.
How
because
long
I
have you
can-
owned this property, Mr. Fernandez? When did you buy it?
1 year, a few months ago.
Well, 1 year? Is a year? A few
No,
months
no,
ago?
no.
No, he's owned it.
January 2023. January 23.
Okay.
It's, I know, 1 year, 2 months. Well, I take almost 8 months to put the permits and finish the job in the roof because it's bigger, as you see. And now I put a new permits. I need, the approve and work and inspection again. Maybe I will need 90 days, 100 days. I don't know what time. But why no?
As far as I'm concerned, you've known since August of last year
But my permits
that
before
you have a violation. Since August of last year, you haven't complied, you haven't even...
Madam City Attorney, can we just ask him a couple questions? Because when we're looking at the roof permit, it looks like that was actually finalized in
before.
2022,
So we don't
before
need to
he
talk
purchased the property, and then the dates that she took the photos, so there's no way that the roof, those were roofing materials when the inspector went out.
Correct.
So we've pretty much just
permit
heard
was
untruth.
on
So you're
December
saying that you did a roof on this property as well?
Yeah.
You did the roof?
Yeah. With
So
permits.
where are your
With the
permits?
city of-
Can we see your permits? Okay.
The permits for the roof were closed, so we're not here based on the roof.
I don't know.
But what he's saying is, I'm
But
just,
on the one hand, he says that he's only owned the property for a year and 3 months. And then the records of the city show that whoever pulled the permit for the roof, it was in 2022.
No.
So it's either one or the other.
Right.
The final inspection was.
he's saying on,
It's,
we do need, let's take this over.
Yeah, but that's
and-
2022.
No, he's got a 2023, that's the reason, let's let,
Well, there's no permit.
I know.
Right.
but-
You see?
That's for a tin
Shingle
cap.
metal, okay, he has the shingle metal tile, it's here. Completed January 17, 2023.
Right.
Correct.
So he shouldn't be cited for that. You gave him the violation on 8/16/2023. What happened is he probably didn't paint it and left it like that.
Well, we gave him the violation for the illegal units.
Well, that you
the
can.
illegal doors on the outside. Addition. The
little
conversion of that side little.
The garage.
The garage. Where he put the parking space slab, what is it called? The bumper?
The dormer.
The bumper.
Okay, so you recommend 10 days?
I recommend 10 days, $500 a day thereafter until compliance is achieved.
For the inspections, right?
Yeah.
So for him to allow her to inspect the house.
And to allow her inside the house.
Because how are we going to know if actually he has illegal unit if she doesn't do the inspection?
Well, we know there's illegal units. We
looks
have
like
separate
4
doors.
We have doors.
Well, come on, we need her to inspect that way.
He's not allowing her to. He became
Well,
aggressive
he
with
does,
her.
are you going to be able to allow her to inspect your house to know if you have illegal units?
Yeah, we are according the.
Okay, if you don't do it, we're not going to give you time and you're going to accumulate fines. So, or either you accumulate fines and you pay for it, or you allow her to go and inspect the property, the entire property, to make sure that you do not have illegal units. It's your choice. Pay fines, allow the inspector to go in.
Yeah, I don't take the properties. It's like existing property. I don't know, is that okay or no?
I don't understand what he's saying.
La propiedad está como está, y ahora como yo la compré, exactamente. Pero no la he tocado.
He says he bought
The
it.
property is the way it is. This is the way he purchased
Well,
it.
translate for him, saying he needs a Spanish translation, that if he doesn't allow her to inspect the entire house, we're going to give her less time and fines he's going to have to pay.
And a higher
Translate it
fine.
to him so that way he doesn't have excuse that he doesn't understand.
What is interesting is that this property has been sold to two corporations since 2022. It was sold from an 8900 Partners LLC, and then almost exactly a year later, it was sold to America South Florida Corp. So they turned it over from one corporation to another, and that doesn't sound too good to me.
And what is his relationship with American South Florida Corporation?
No,
let's
that's
see.
my company. But, this was
A short sale, quick deed?
no.
it's no
That's
short
the wrong in the deed. They put core as my LLC. That's mine. But they put wrong core.
They put the wrong core.
That's a mistake.
America
Oh,
South
it's
Florida
no mistake.
LLC.
It's part of the county property records.
That one.
I mean,
Ready for
that's not a
motions?
mistake.
Motions? Come on,
It has a page number. It was sold from
I'm leaving in 20
675, and then they went ahead and did
Yeah.
some sort of corrective tax quick claim deed.
Quick claim
is
deed.
what they did.
Maybe they did a refinance moment.
Could the translator, I just want to say this. Could you let him know that even if he did not do the illegal work with the illegal units, that when he purchased the property, he assumes the liability for those things to bring it into compliance?
Yeah, but I'm working in bringing the complaint. I
Okay.
respect the inspector. I say I do the new plans for existing property.
Yes.
If something is wrong,
Fix it.
they'll fix it
You'll
now.
fix it. Gotcha.
I'm working with the city right now.
Okay.
The permit is in the city.
Great. So
Is
now,
there a permit, Mr. Director, is there a permit filed with the city to legalize the illegal units?
Yeah, I have everything here.
hold on, she's
That's the number.
Ah,
That's the new number.
Can you please show it?
Can we move to
Show the inspector.
I'm here for half an hour more and I'm gotta go. So, you take a pick. I think you have 4.
He's entitled to speak. We can't rush it.
Yeah, I don't want to.
So when you speak, you take your time. He needs to speak and take his time.
It's
That's
been-
what we're here for, to
It's
listen
been
to the people.
corrected. It's been-
We're here to
They
listen to the
haven't
people.
accepted yet. It's-
Right, they haven't accepted. So,
They haven't done anything.
look, at the end of the day, Madam Chair, the records in the city, it says building, master, permit not pulled. I just,
Pre-screen.
Pre-screening. and
That's
top.
what it says.
Meaning he hasn't done anything else in it.
Right, and he hasn't done anything since August of last year. Again,
So-
how much time do you want to give this individual to continue to not do anything, and and we don't know if there are illegal units there?
Can you click there on the BD number,
there are.
please? On the BD 24-006, can you click on there? No.
Can you ask him how much
we were
time
just
he
there.
needs? Ask him how much time he needs.
On the process number. Okay, that one is, you just passed it, you went, okay. Go ahead.
He's asking for 90 days.
But 90 days, but he has to allow her to go inside and check
meantime.
every
Click
unit.
again on the BD 24 because
Yes.
I just saw something that says
Like
March.
a system, but I don't do
Click
it.
there.
You let her inside and check everything.
Okay, yeah.
Okay, so,
March 24.
so then.
He has an application for remodeling repairs that was created on March 21st, 2024. So he does have an
He
application.
does have an application.
He
For
hasn't
these
paid or
repairs.
fill it up.
So
Yeah.
he is correct.
It's working.
No, he
Please.
has an application, but you see here pre-screening, meaning he hasn't finished finalizing the
doesn't
first
matter.
application.
He put an application in. There's people that come here 8 months and haven't done
but-
anything. He has an application in the system. He's
Yeah,
working on
So
it.
you both are correct.
So saying
Well-
that,
Yeah, but I work with the architect, where new plans and everything. That takes a long time.
I understand.
Madam Chair, I'm ready for motion.
Yep, we need a motion.
Okay, so let me explain. If you say and tell him you commit to letting her in, let's say, right? And then you say 90 days,
there's conditions.
there is not going to be any ability for her to come in.
Well,
That
you
is
haven't,
why
you haven't
I'm,
allowed us to vote on
Let-
it.
let-
That
Let
was one
me-
of the conditions that was discussed.
and that's
So-
why I'm saying
Right.
Let them.
I'm requesting a guilty, 10 days to come into compliance.
To allow the inspector in the
To
property.
allow the inspector,
And $500 per
he can then apply for an extension of time. The inspector will report at that hearing that he allowed her to come in to inspect the premises and that she supports more time. That's my recommendation.
Thank you. Do I have a motion?
I make a motion to move as stated.
Second.
All in favor? Aye.
Aye.
Tell him
Can you
exactly what
explain
he
it to
has.
him, please?
Next case.
He needs to please speak to the inspector so he doesn't get fined on the 91 days.
If you can go with him
10 days.
to
10
speak
days.
with the inspector.
10
Excuse
days,
me.
no, 11.
Can we clarify the motion, please?
Thank you.
Thank you.
10
Next
days,
case,
finding killed 500.
I'm sorry, next day?
10 days.
Okay.
10 days guilty, 500.
Okay, thank you. Calling
I
next
thought it was
case.
90 days.
Calling page number 25 to be heard. This is in the code check agenda. The address is 2901 Northwest 7th Street. Case number is 000-67412. Address 2901 Northwest 7th Street, page 25.
Good afternoon. Please state your name and address.
Jenixie Diaz, 9300 South Dayton Boulevard, Suite 600, Miami,
Guilty
Florida.
or not guilty?
I guess guilty.
Thank you. We'll let the city present its case. We'll come back to you.
Okay, was this a guilty or not guilty?
She said guilty.
Okay.
Inspector, good afternoon.
Good afternoon, Inspector Torres with the BTR Task Force. As a random check for this shopping center for CU and BTR, I found the unit 2901. It was a smoke shop operating without a CU and BTR. Also, they have a sign, electrical, done on a property, also without a permit. So I signed up for CU, BTR, and the signage. So far, they already obtained the CU and the BTR, but they're waiting on the permit for the sign.
So what is your recommendation to the board?
My recommendation to the board would be another 90 days so they can finalize the permit for the signage.
Okay. Ma'am, is that sufficient?
Yes.
So we're requesting guilty, 90 days, $500 a day thereafter until compliance is achieved.
Any discussions from the board? No? Do I have a motion?
Motion as stated.
Second.
All in favor?
Aye.
You have 90 days.
Thank you.
Thank you.
Pay attention to your application. Your application hasn't been
Next
corrected.
case, please.
Yeah, I saw that. Thank you.
Calling page number 198, address 3852 North Miami Avenue. The case number is 000-67332, page 198 to be heard, code check agenda. Address 3852 North Miami Avenue.
Good afternoon. Please state your name and address.
Good afternoon. Christopher Pinellas. Law office is located at 98 Southeast 7th Street, City of Miami, Florida.
Guilty or not guilty?
Pleading guilty.
Thank you.
Inspector, please state your name and give a brief synopsis.
Senior Inspector Comer, North Office. We had a hearing on January 11th and the attorney was advised not to open up well, he can't get permission, but he was advised that without having the certificate to occupy the property, to delay everything. So as of now, the property is being used as a gym. So the first violation is work without permit, and there's building violations that's on site. Give me a moment.
Do you need water?
I have to go get some.
Okay.
And there's building violations that's on site, and they should have a certificate of occupancy, and they don't have one. So they're operating without having that. And they do not have a certificate of use nor business tax receipt.
Well, they can operate if they don't have that.
They cannot operate.
I'm right, that's what I'm saying. They cannot operate. They need to be closed.
Counselor, has anything occurred? Have they filed an application? What's going on?
Yes, and for the record, the situation that's at play here is that this is a tenant of my client's. Part of their lease is that they are required to get the necessary permits. Obviously, they have not proceeded through that process. My client is now taking over the process. They're going to be pushing forward the permits for them. We have submitted and taken over the application on behalf of them. There's been a resubmittal on the active permit of the property that happened, I believe, earlier in March. We're working on those revisions. That should be resubmitted towards the end of this week. And then shortly after we finalize those permits, my client will be working towards getting the BTR and CU to bring these into compliance. So that's the scenario that we find ourselves. We would just ask for additional time to work on those permits, whatever the board would be open to. And that's the position. Thank you.
Inspector, do you have a recommendation as to how much time?
Work was done on the roof and everything, and there's people that's occupying the spot with customers, so they should not be active until everything gets resolved.
Right.
So,
if I may, counsel.
So you have a certificate of occupancy.
Occupancy.
We do not, is my understanding.
So,
Work without a permit.
so it's worse than have no CU, meaning they did work in the building, and the city of Miami has not authorized the owner to have anybody. You're an attorney, right? You know what that means. That your client is having people inside the building without the city approval. Not a certificate of use is nothing, comparing with a certificate of occupancy.
Yeah, no, they should not be operating at all, like I stated before.
If I may, Madam Chair and board member, the roof permit was finalized. That was a separate issue from the work without a permit. The roof permit is finalized on the record. That's been completed and rectified. It's my understanding that has been completed. Work without a permit was, my understanding, to deal with internal improvements. The structure is safe. I'm happy to provide the city with a letter from an engineer stating that
You haven't had the fire department go out there. The fire department has to go out, so
Maybe send a different.
this is, the building could look beautiful. It could look like the Taj Mahal. It doesn't matter. If you don't have the proper certification and the certificate occupancy that the fire department has cleared this property, if anything happens to anyone in there, there's a big problem. I'm not saying it's going to. The place looks great. I would love to join the gym. But you don't have the proper documentation. You're exposing yourself to a liability, your clients. So you cannot operate until all this is resolved, mainly the certification.
Understood.
So if you have that, that'll be great, but you cannot operate.
Through the chair, what's preventing you from getting the
CU?
Yeah.
CO.
Well, the CU and BTR, which is the case at hand right now, is basically we're finalizing the permits. And those permits have been in process. Again, the tenant that's there has taken a long time to do so much that my client has now come into possession of that application process and is pushing it through. So, we're resubmitting, addressing the zoning comments that are at play next week. We're hoping that once those permits, comments are finalized, we would be able to get those permits issued, CO issued, and then the CU and BTR thereafter.
So counsel, hold on, if I may. So one of the concerns, I hear you loud and clear, and it is your client. But one of the huge concerns, and we just ran property appraisers to make sure the property address is correct and the folio is correct. You just made a comment a little while ago that your client is making efforts to have everything as far as building permits. Under that address and that folio, we're showing nothing.
Well, if I may, there's 3850 and 3852 are the same parcel. So if you search 3850, there is a permit. I have the permit number here if you'd like me to provide it for you.
Probably under the main.
Yeah, for the record, the building permit is BD23
Got it. So for whatever reason, the 3852 and 3850, okay, all right.
2 units.
Right, and we ran it under folio, but yeah.
And
that's not
Counselor,
part of it.
we understand that the property owner is now getting involved in moving forward with this, but the tenant can't be allowed to operate. That's the concern that's happening here. How close are you to getting? Yeah.
It doesn't matter.
We
He doesn't
can't,
have
you need to give him 24
the
hours,
certificate of occupancy.
and he needs to vacate.
It's not certain if zoning allowed that particular building to be a gym.
It's dangerous.
Right.
Oh, we don't even know if they have approval.
No, they don't.
They don't.
They don't. And the problem is if we allowed them to stay, don't put a position of you cannot have anybody there. If something happened, we as a city are reliable because we are knowing that you don't have a CO.
Yeah, this is like an immediate compliance case.
Immediate compliance.
Yeah, this case, I mean, I don't know what the city recommends. That is what I recommend, board members with.
I was ready to say 24 hours, but
Because this could be people can.
I don't even think we say 24 hours. I'm going to say immediate because, I mean, I'm a business owner. I've been through this process before. I've even sweated it to the last minute with events and things like that. But let me tell you, even after spending close to $1 million, if I didn't have a CO, it wouldn't be open. Okay, that is a decision that a business owner has to make because of liability. Their liability insurance doesn't cover if they don't have a CO. So I understand where you're at, but at the same time, I'd say this is an immediate closure.
Yep.
So I'm going to make a motion for an immediate. I'll take the onus on this and a fine. What's the maximum fine, Madam City Attorney? For
It's a business, $500 per day.
$500.
For a business, 1,000.
1,000. That's what I was thinking. Okay.
Yeah,
So
remember the
$1,000
statute
per day
was amended.
thereafter if they don't come into compliance.
Do I have a second?
I'll second.
All in favor?
Aye.
You need to shut down, sorry. Next case,
Calling
please.
page number 207, address 782 Northwest
No.
21st Terrace, case number 000-19428, address 782 Northwest 21st Terrace, page 207.
Good afternoon, or good evening, actually.
Good
May you
evening.
please state your name and address?
Attorney Christopher Guerrero. I am located at 3105 Northwest 107th Avenue, Suite 400, and I am here on behalf of the owner of the property.
What page number, Melanie?
207.
Thank you.
Guilty or not guilty, Mr. Guerrero?
The property is guilty.
Thank you. Well, is there anything you've done so far to be able to remedy the violations?
If I may, can I allow the
Yeah, sure.
the inspector to go first, and then
Hi,
I'll give you
Inspector.
guys.
Good evening, Board. Inspector Lezama, Compliance Central Office. I have spoken with the attorney because this property was cited previous year, and they hadn't responded, but he gave me an explanation that the property owner passed away.
Okay.
And the lady who inherited the daughter, inherit all these properties, she needed to fix with the documents, and plus they were not receiving the letters because the property address where the father lived has changed because he's no longer there. So, but they did a procedure. I think he presented the documents of eviction because the tenants are taking advantage of them. So they also going to need time for getting a permit, getting permits, but they need to do the eviction
First.
First, yes.
Okay, and they haven't done the eviction since you cited them in August?
They haven't received the notice because
Oh, okay.
they.
When did they get notified? Recently?
No. Yes.
If I may.
Okay.
So the officer is correct. My client's father was the previous owner. She inherited these properties. The notifications were going to a address which is on this notice of violations of summons to appear at 961 Southwest 58th Avenue. That's a rental property, which she also inherited. As you probably can expect, the tenant wasn't giving her any of the mail.
Right.
And so when she finally did a notice of, or address forwarding. She got this notification earlier this year, and once she got it, she forwarded it to me somewhere around February, late February. And so I had a conversation with her, and I advised that one of the things that we need to do is get this person out, because we're not going to be able to remedy any of the violations with this tenant that is in there. One of the reasons is because the tenant is month to month. So by way of background, we gave him a notice of non-renewal for the tenancy that he had on the property. And so now that the period for him to get out has expired, I went ahead and filed an eviction action in Miami-Dade County. So we do have a active eviction running right now, and I have the case number if you guys would like to have that for your records.
Is this the first part of the eviction?
This is the first part of the eviction. So it was just filed Monday, because that's as soon as I was able to file it, because I had to wait for him to have the opportunity to move out per statute. He did not move out, and so now we are dealing with the eviction portion of it. My client has all the intent in the world to comply with these violations. It is also an understanding that there is a violation for work performed without a permit, which he obviously had no control over that. Right. And so once the eviction is over, we have to also deal with the building permitting side of it. We don't know what those, the work that was performed, but we're going to deal with it. And she definitely wants to bring all of this into compliance.
So how much time do you need?
At this point, just to be quite candid, because we're dealing with the eviction aspect of it and then the City of Miami building permit side of that, I would say if you guys would graciously grant us 180 days, I think that would be more than sufficient, because our goal is not to come back here and take up your beautiful time on your docket. We would want to work with Mr. Lezama.
Right.
I had mentioned to him that we also want to meet with him very soon, as soon as next week, to be able to go to the property, for him to walk with us and show us everything that is wrong, so that way we have a clear understanding of what needs to be done and bring everything into compliance as soon as possible, as we're able to.
Counselor, would you live 180 days next to that? Because they can't even pick up the property. I mean, I would not say to give them more than 30 days to clean up that property at a minimum.
If that stuff is not theirs, and if it's the tenants,
there's
they
a
can't touch
tenant
it.
there, and unfortunately our hands are tied until we legally get the person out. I mean, we can't use self-help measures, because it's against.
Madam Chairperson, this is a property that was cited in July of 2022.
I know, but if they're going through an eviction and the person that lives in that property, all those items belong to them legally, and you should know this, they cannot touch it, because they can be sued.
I know what legally can and cannot be done. However, the board can say you've had since 2022 to evict these people and you did not, and therefore we're giving you 10 days, 5 days.
Thank you, Counsel. Board members, do you have any further discussion?
When did the owner pass away?
The owner passed away in March of 2022. The daughter inherited the properties, and like Mr. Lezama mentioned,
you go through probate, it takes 1 year.
The daughter has had the property for 2 years.
You go through probate, it could take a year, even more.
Yeah, the owner inherited the properties, but again, she wasn't getting the notices. It's like getting a lawsuit and not knowing that you're called to court. She can't rectify something that she doesn't know exists. And again,
she have to take some responsibility. She knows she inherited property, right? So got to take some responsibility for it.
Yeah, I wouldn't give them 180 days. I would give them less to come back and see where they're going as far as the eviction is concerned.
I'm with the city attorney regarding the 30 days, because this has been going on for 2 years. And it's not going to get any better if it's.
Yeah, but I think this is a situation. Look, we gotta understand Florida still has laws in place for that we just can't violate, and I get it. I would agree with you. 30 days, 60 days. Bring them back, get a mediation once we see.
At least he has to come back in 30 days.
Correct. I would say, bring them back, but not an immediate, not a 5 day, not a 10 day, because we just can't do that. I would say for me, I would say 60 simply because if he's
Yeah,
filed
60.
for eviction, he's given the notice of non-renewal, the process has already been started, the tenant is informed.
He has to wait for the
court-
key.
When did
the
you,
courts
when
has to
did you
run its
send
course.
the, when did you evict the
So
tenant?
the notice of non-renewal was sent on the last day of February.
Correct.
They had to move out by March 31st. As I mentioned, I have the eviction here. I can pass it to you guys so you guys can look at
I
it.
need to see
It has in the letter that I sent the tenant, I let him know that the city had cited my client. It had come to our attention that the city had cited my client for these violations, that he needed to go ahead and rectify these things immediately.
Correct.
He has since not done that.
So
We have no ability to rectify these things because he is in the property right now, right? So now our next step, which is required by law, is for us to evict him. We don't have a way to get him out,
Correct.
or know how long it's going
Is
to
he
take to get him
living
out.
on the property?
Huh?
Is he living on the property?
Yeah.
That is our understanding because he is the tenant. We can't confirm that 100%. It's a residential property, but as you can see from the pictures, he's
everything
doing
else.
other stuff there.
Yeah.
No, that's a
Beyond our
D1.
control, and
It's a
that's part of the
D1.
reason why I had recommended to my client to get this guy out because there's no other way around it.
Okay, well, we have a motion. So you said 30 days?
I said 30 days.
And how much per diem?
$1,000 per day thereafter. I think that's the most, right? Madam City Attorney?
Do I have a second?
What's the most per day for this property? Because it's.
It's a D2.
It's a D2, commercial,
So
industrial.
$1,000 per day, it could
Yeah,
be.
you can do 1,000.
Do I have a second? Motion dies.
What's the motion again?
Oh,
Can you
30
repeat
days,
Motion was
$1,000
30
per
days,
diem.
$1,000 per day, just so that he has to come back and it puts a little stress on
Well, evictions
them
are
getting
not
this
going to happen in
cleaned up.
30 days.
No, but the guy's already supposed to leave. The guy, he's got his
But-
eviction.
He's not gonna leave until the eviction is not
Yes,
done.
so let me clarify.
The eviction's
The eviction just got filed Monday.
Right, it's
right?
not, it's going to take 90 days or
there-
more. We know that, but
Realistically speaking, we don't have, I can't ethically tell my client it's going to be.
I know.
He's going to be out by this day. And then mind you, even if I get a judgment against this gentleman, I still have to execute on the writ of possession,
you got to get
which
the writ,
then
and
I have
the
to get the sheriff to do
go
that.
out and take all that out.
And that all has a process. And then we also have to find a way to get all this stuff off the property. Again, my client's son is here. He's the grandson of the gentleman who used to own all these properties. Again, my client's intent is to comply with this as soon as possible. It's just her hands are tied, and she can't legally just take all this stuff and throw it out.
Okay. Motion dies. Do I have a new motion?
I have a motion for 90 days, $1,000 per day shortly after.
And allow the inspector
And
in?
allow the inspector in.
Okay,
to
once the
walk through.
tenant leaves?
Correct.
Okay. Do I have a second?
Second.
All in favor?
Aye.
Thank you.
Thank you.
Have a good day. Good
Thank
luck.
you, board.
Hello.
Next case. Thank you, sir.
Calling page 116. Address is 2450 Northwest 36th Street. Case number 000-61701. Page 116.
Oh,
Address-
116.
Yes, 116.
Thank you.
Page, the address
Good
is
evening, sir. Can you please state your name and address? Over here, the lady in red. You can't miss me. How are you?
Fine, you.
Please state your name and address.
My name is Ignacio Matos,
Mr. Matos. Are you
2450 Northwest 36th Street.
Okay. Are you guilty or not guilty?
Well, had to be guilty, baby.
Oh, no. You tell me. You don't have to.
The property, remember. Always the property, not you.
We'll let the inspector put on his case, and we'll come back to you for comments. Good afternoon.
Good evening.
Good evening.
Daniel Gamara, Co-Compliance After Hours. The property, we did a task force dry hour late at night and saw that the property was selling hookahs and operating a valet parking, which they took care of the hookah, but not the valet parking. Also, they have signs on the windows that need to be taken out. That has yet to be done.
He has not.
He has not.
Okay.
The signs are still on the windows, covering 100% of the windows, no visibility to the inside of the property of the restaurant.
Okay. How many days? What are you recommending?
5.
5 days?
Simple.
This is an August violation of 2023.
Yep.
So it's been 8 months for something so simple.
Correct.
Immediate. Yeah, 5.
Any comments?
Sir?
I'd like to hear from him.
Would you like to say something, sir?
How much time you need?
Yeah.
Why haven't you taken those signs down? Why has it taken you so long?
Yeah, because I want to ask you if do you have the picture on the screen, please?
He wants to show a photo of the building on the
Yeah.
exterior.
Do we have a picture of the building?
Yeah, Frankie, can you show the pictures of the building?
A picture of the building.
Outside, the building outside.
Outside.
What it
The
looks
facade.
like. The exterior. Where you had that yellow big sign. Okay, those are the signs?
Yeah, those signs I have it in the front just to show that the food that I sell. Your Honor, I don't know if I can. I don't take the sign out just to come over here to see if you accept that I take one and keep it, just take every other, not 100%, like a 50%.
No, you
To
can't
just
have
You
it.
can have it.
By the code, you're allowed 20% and with a permit.
Excuse me?
You need to obtain a permit, and by the code, it's only a 20% that you can have the window covered.
So you,
I take it out if you want to, no problem.
Yes.
You never come tomorrow to inspect, I take it out tonight.
Okay.
Sounds good.
Huh? You want to go today?
No.
Go tomorrow. I know inspect if
Sunday,
you want to.
Sunday is a good day.
So I got the BTR for the hookah. That what you want to?
Correct. That was
look at it?
that was part of the violation that I gave that day.
That's the only
But
thing that I have. I had just two violations.
Sir.
The sign and the hookah.
Sir,
Okay.
You have to relax.
Don't.
You cannot be upset because you did something wrong. You don't have a choice to do what the city needs according with the code. It's not the inspector's fault that you did the windows wrong. Whoever did the windows for you is the person who did it wrong because they know that that's illegal.
Right.
And you paid somebody to do this knowing that they're illegal, not you, but they know it's illegal.
Okay.
So it's not the inspector's fault. He's just doing his job.
All right, he did a good job. 5 days I have? 5 days?
We haven't decided. They haven't decided yet. You have to wait for them to decide how long they're going to give you, sir.
All right.
Do I have
What is the city recommendation?
motion? The city recommended 5 days.
But I have a question, something about the parking. Is it being operated as a parking lot without a permit?
Compliant, right?
that was after the fact for the no certificate of use, the valet parking that they have there.
But he's in compliance.
You can see in the pictures.
I don't see it. We see the same picture over and over.
Yeah, Frankie, can you go to the one that says valet $15, please?
But the question is he in compliance today?
No, he's not. Because he still has those windows.
This-
Oh, you're talking
No,
about
I'm
signs
talking
and
about for the
ordinance.
parking.
No, the parking, he's in compliance.
So
correct?
he's in compliance for the parking, okay.
Yeah, he needs
Yeah,
he
he's
needs to
in
comply with
compliance.
that.
So we're just talking about the signs.
Just talking about the signs.
That's really the
so
problem.
sir, did you
Correct.
understand that you needed a permit for the signs?
Even the one on top, the big one.
Correct.
So he needs to
He
do
needs
all
the sign for the-
windows, and
for
the big
the-
one that says parking, Ceniz on top, you can't have that sign either.
I can have the
The
parking sign.
big one on the top of the roof
The last
that
of
says Ceniza parking, you can't have that. It's too big. That's not allowed. That is not allowed.
And the one in front of the establishment that also needs a permit.
The one in the front, where? That's that
Where
yellow?
it says La Ceniza, it's by the windows as well.
Okay, you can't see that.
Inspector, have you discussed with him the procedures to go about getting the proper permit for those signs?
Yes.
So we're going to have a supervisor participate as well, because I
Yes.
don't want him to.
He's too hesitant.
Yeah,
He's
correct.
too.
Correct.
Okay.
What is the city recommending? Inspector recommended 5 days?
5 days.
$1,000 per day. Do I have a motion?
I'll make a motion as is.
Do I have a second?
Second.
All in favor?
Aye.
You have 5 days to remove all these signs.
And what was the fine?
Thank you. Please keep in touch with the inspector. Thank you. Next case?
Thank you.
Thank you.
Calling page 8, this is in code check agenda to be heard. Address is 78 Northwest 57th Street, page 8, case number 000-57850. Mr. Harold Kumar?
521 Northwest 7th Street?
No, page 8.
Hold on,
Code
I'm in the
check.
wrong page 8.
78 Northwest. Did you
Oh, got it.
What page is it?
Page 8.
Page 8.
78 Northwest 57th Street. Harold Cobbmart?
Oh, it's dead.
And it's not here.
No.
It's dead.
Reset. No file.
And this is dead. That's right. This is, yes.
Yeah. Good evening. Please have him state his name and address.
Our group 68 Northwest, 57th Street.
Guilty or not guilty?
Guilty.
Thank you. We'll let the city present its case. We'll come back for.
Inspector, state your name and official position.
𝐂𝐢𝐭𝐲, Code Compliance North.
Okay, give a summary to the board as to what the violations are.
It's a 311 complaint regarding junk in the yard and a fence that was built without permit. He started removing some junks, but there's a lot of left. So I would give him like 120 days to comply because it's a lot of junk.
Okay, so we're asking for guilty, 150?
Yes.
120 days and $150 a day thereafter?
Okay.
Okay.
Is there any city assistance we can give this gentleman? Because he's an elderly gentleman. He obviously needs help.
Yeah.
Apparently he's hoarding.
I'm going to refer him to the commissioner's office because sometimes they have a list of services.
What district is that?
This is District 5, King?
Yes.
Yes.
Question, so he understands he has a violation, he understands that stuff needs to be cleared out. He's okay with that being willing to be cleaned out?
Yes, he's okay. Start the cleanup already.
Can we verify that? If he's okay with that?
If we give him assistance.
If we give him assistance?
He's not familiar with the violation.
Okay.
Oh my gosh.
Could you explain to him that he has a bunch of illegal things in his yard, trash, debris, etc., and it's not supposed to be there. It has to be removed.
Thrown away.
I think that this is a case where we need to refer it to a guardianship because obviously there's not family taking care of him and he's not understanding.
Yeah.
He said everything is removed already.
And if they have to sell the house in order to provide for him, that'll, provide for his care.
Okay, when was the last time that you passed by, Inspector?
Not everything have been removed. That was yesterday. Not everything have been removed. He started to remove some stuff, but there's a bunch of
Yeah,
stuff
he needs assistance.
left.
It's a lot.
It's a lot.
And see, he's in my district, so I could, and I've offered this before, but I can send a dump truck to him. The problem that we had the last time is that they fight the individuals.
They don't want to get
take
the
the
things.
stuff.
Yeah.
So I don't want to incur an expense unnecessarily if you don't want the help.
The thing is, it was a business that he had somewhere else.
Yeah, and they brought everything,
and then he brought everything to
over there.
He said he will be agreeable to that.
He'll be agreeable to a dumpster being placed outside.
Yes.
And some helpers taking everything away.
Yes,
Is there a fee?
No.
Okay, I just want to make sure he knows that.
At your expense and for how long? Because I don't want to.
That's what I don't want to have a situation where they fight the people that we send to go do it, and they're saying, don't take this, don't take this, don't take this, and it just
that's going to happen.
Continues to go.
So you are going to voluntarily put a dumpster there?
But it's so much.
But it's a finite period of time.
A question. How much that he has? Because I have a same case in District 4 right now that we're working on it, that we're going to get a couple volunteers to go the day before the city pickup and have everything be outside, right?
He has a lot.
Okay, in the pictures.
Most of them in the back.
You need a dumpster for this. Yeah. He's hoarding.
Well, I will get you volunteers, and let's team up and do 4 and 5 and clean up our city. What do you think? Okay, let's do it. What? I guess we will go through you, Inspector, and
Do
try
I have
to
a
coordinate.
motion? Because
90 days?
while you decide, you guys can talk to him
How long
later.
do we need?
So we have
Our recommendation was guilty, 120 days, $150 thereafter until compliance is achieved.
I'll make the motion
I'll
as
second.
as stated.
All in favor? Aye. Then you guys talk later or give them your numbers and you guys
Inspector,
can.
just reach out
Next
to
case,
us.
please. Thank you.
Calling page 23.
Thank you.
Address is 5651 Northwest 17th Avenue. Case number 000-80726. Address 5651 Northwest 17th Avenue, page 23. Mr. Exile St. Vilas?
Yes. We can work on it.
Is a, okay.
Oh my God.
Maybe you want to give him the microphone
It's
instead
dead.
of him walking to the podium?
You can have a
Microphone's not.
I'll get you a microphone. Yeah.
Slowly but surely.
Do you need translator?
He's moving.
Do you need translator? Do you need translator? No?
Do we have a microphone or?
They're going to get a
another
microphone.
microphone. It's dead.
Okay, great. Thank you. 23.
Page 23.
Page 23.
I am.
Director, I have the only to be heard I have left. There are absentia cases where there's folks signed in.
Okay,
However,
so for now, let's table that. Let's proceed with
Yep.
the
extension
extensions or
after-
mitigations that people that we have here.
But we have,
I
Please-
got a new
I
mic.
just
That one
heard.
was dead. I just got a new, fresh one.
okay. How does he please?
Sir, can you please state your name and address?
Oh.
State your name and address.
What do you want to say?
Say it again.
Yes, I just want to know why I come in here.
No. You need an interpreter?
Yeah,
I think we need a
I
translator.
have a property,
Okay, what's your name and address?
5651 Northwest 17th Avenue,
And your name?
Exile,
Last name?
Exile Saint Phallus.
Okay.
Thank
Yeah.
you.
Pardon?
Is he guilty or not
I
guilty?
could help myself. Now you could sit there in case.
Guilty or not guilty?
Do you plead guilty or not guilty?
It's the property.
The address again?
No, but when you say that to people, people think it's them. It's the property. They reject it.
As long as I'm here, I'm proud. I'm guilty. I don't have to be there.
It's those.
We can't understand what he's saying. Is he guilty or not guilty?
Guilty.
He's guilty?
Guilty. Okay, go
Guilty.
for it.
He says guilty?
Guilty.
Okay, well, let the city present its case. Thank you.
Can he say into the mic yes? Can you ask him?
Yes.
Okay, thank you. Okay, Inspector, please state your name and official position and provide a synopsis for the board.
Anishka Anderson, Code Compliance North. I received a complaint about this property having stuff stored on the outside, so I went by and they do have a lot of stuff stored outside. There was a refrigerator, a hot dog cart. It's a parking lot, but it's not being used as a parking lot. They're just storing stuff outside. I posted the notice of violation. I spoke with the younger guy. I don't know if he owned the property, but I've never seen this gentleman, and he's never contacted me, but I cited him. So far, nothing's been done. They still have the stuff outside.
Yeah, I'm gonna wait.
Okay, so, and you provided me with your file in this case, correct?
Yes.
Okay, and the photographs that are being shown, they accurately depict the violations that you cited him for?
That's correct.
Okay, and who's the gentleman that was on the inside? Did you recognize them or did you speak to them?
That was the gentleman that I spoke with.
Looks like he's living there. Looks like there are people living in there.
Are those RVs where people are living or what?
Possibly. I was never able to go inside the gate. All the pictures were taken from outside the gate, so
yeah, that looks
they may be living in there as well.
Mr. Translator, can you please ask him if he knows about the violation, about he cannot storage anything in there? No hot dog car, none of this cannot be there. Can you explain to him?
No, because the gentleman speaks English, and he's assisting him, just.
Yeah, all of them remove. Yeah, everything's already been clean. Take it out, yeah.
What is he saying? We can't hear what he's saying.
Yeah, I remove everything already. It's been
What was the
settled.
last time, Inspector, that you went to the property?
A couple of days ago. It's not moved. It's still there.
Sir, Mr. Sanvillas, are there people living in that parking lot?
Inside the trailer.
I can't hear what he say.
Are there people living in the parking lot?
Oh, only one guy. He got a little camper on the side close to the gate. That's the one he stayed there. Otherwise, I'm here too. Yeah, I'm on the side of the building.
He's saying that there's someone in the camper that is staying there.
Okay.
Okay, so there is someone in the camper staying there. Can you tell him that no one can be living in a camper in the lot? This is very.
Well, it's a parking lot. Nothing can be there. What are you recommending, Inspector?
He said he asked them to move already.
Okay.
I mean, if they're going to start working on it to remove the stuff, possibly 60 to 90 days.
Well, you just gave him the
He said-
violation like 2
He
months
said he
ago.
asked,
They haven't done
he
anything
asked
so
the
far.
gentleman to move, and the gentleman is already moving his stuff out.
I'm sorry, I can't understand.
He asked the gentleman to move, and the gentleman is already moving his stuff out.
Okay.
Shall we give him 30 days to see how this is progressing?
That's fine.
Do you think that's fine?
Yes.
Okay. Do I have a motion or
Let's make sure.
to give him 30 days for now to see how is it going? He just got this violation.
He says if he could
To
give
see-
him at least 60 days.
30 to 60 days?
60 days.
Let's give him 60 just to make sure he gets it
I
on.
was
And the
gonna say
fine will
90,
be?
just for good measure.
It's to remove everything, not just the person,
Correct.
right?
It's
I think he
everything.
needs to
He says he needs 60,
understand
so I
it's
vote we give him
everything, not
60.
just the person.
My son, they're not going to be
yeah.
removed.
Yeah,
60?
I'm thinking 90.
Okay, go for it.
We're recommending, we're recommending a guilty, 90 days, $250 a day thereafter until compliance is achieved.
Do I have a motion?
So moved.
Second.
All in favor?
Aye.
Thank you.
Can you explain to him that he has 90 days, and after 90 days, a fine of $250 a day will start?
And that he
Okay,
needs
he's
to clean the
asking that-
entire
Thank
lot.
you.
He's asking that why does he have to move the cars? This is his lot.
Oh.
He has to move the hot dog stands. He
Everything.
has to move all the trash. He has to move
All the RVs, the cars.
all the cars that are inoperable or untagged.
Wait, the director, through the chair. I mean, if it's a parking lot, can you register it as a parking lot?
No, it's a T5.
So it's a T5. Go to the, it is not, it's a
That's why I'm looking like,
multi-family
Yeah, it's right next to the
residential.
residential. It's right there.
That's what the zoning, by the way, it's immediately next to a single-family home.
Yes, and I see it's a parking lot right next to it. It's on the other side of the street.
Yep, and that parking lot behind, that's a
Behind.
T5 as well.
But that's a
the
parking lot.
zoning. Well, the zoning, I'm looking at it. T5.
I'm just looking at the aerial.
Right. And so what's of concern is that property, the gentleman's property, abutting that single-family home in that condition.
Understood.
Next case, please. Thank you.
Moving to the extension of times. This is an extension of time in the code check agenda. The city view agenda, page 26. Address is 1642
Front of the
Southwest
green
18th Avenue. Case number is CE 2021-019735. Address is 1642 Southwest 18th Avenue. This is page 26 in the city view agenda, extension of time.
Good evening. Name and address,
2021?
please.
Good evening again.
Page 26.
Mickey Marrero. My address is 200 South Biscayne Boulevard. Here on behalf of Diaz-Granado family, the property owners here.
You're not- I mean, how much time do you need? I'm sorry?
We really need 6 months, and I can explain why.
Okay.
But if it's less, we can come back. So my clients bought this home in 2021. This was a family, and the reason they bought this particular home, it had an extra area for the grandfather, the father-in-law to live, and it was basically a perfect home for them. When they bought it, it had no liens, no violations, seemed like a great situation. So they have a family, so the abuelo takes care of the kids, that's why the house works. When they bought it, abuelo installed the fence. He didn't realize he needed a permit, unfortunately he did, so he got a violation for the fence.
Abuelos always don't think that you need a permit for a fence.
So does mine.
Installed
It
a
did mine.
very nice fence.
What's that?
It looks very nice.
Yeah, no, it's a great job. But
They did a
anyway,
good job.
it needed a
Abuelos
permit.
handy.
So simple enough, get a fence permit. Unfortunately, when he submitted for the permit and zoning reviewed it, they realized there may have been an addition done decades ago without a permit. They had no idea. So we were then hired, and my partner's handling the zoning, to get a variance to allow this addition. We submitted a variance application in November of 2022, and it had been going through the process. Sometime in 2023, zoning changed their mind and said, you know what? Because it's a single-family home, and because it's their residence, you qualify under an exception for a waiver. You don't need a variance. Great news. We withdrew the application for zoning. We submitted in December 2023 for the waiver. That is still being reviewed. We're still getting comments. You all know that takes some time. So they're anxious to get done with it. We can't get that fence permit until this is closed out. But we've been anxiously, working on it. And, my partner says we need 6 months and then it'll be done.
Code recommends 180 days.
Motion for 6 months.
Well,
Oh,
do
sorry,
I have a
180
second?
days.
Second.
All in favor?
Aye.
Sorry, I
You
meant
got
to
6
say
months.
180 days. I'm sorry.
What was it, 180?
180 days.
180 days.
80, okay.
Must be the tie, Mickey. That orange
Yeah.
tie is really good.
Next
Okay.
time gonna be 0.
Thank you.
Okay, so do all the board members agree 180 days?
Yes.
Okay.
Next case?
It's homestead anyway, so we don't have too much,
But, I just want consensus.
He's also here for mitigation. Should we wait or just keep going?
Mickey is the orange tie. Go.
What page?
So you get
This
to
is
see the
the-
kids earlier. Go.
This is the mitigation. It is an add-on. It's at the bottom City View agenda. It says add-on P3. It is behind the green portion of your booklet, the green paper of your booklet in here.
Yep.
It's add-on P3. The address is 880 North Venetian Drive. The case number is CE 2020-007-366, 880 North Venetian Drive. This case is 836 days old.
800?
Yes, 800.
That's 100%.
Well, but this is,
It
there's
used
a
to be,
different.
is it a
Chairwoman,
residential?
this is because it's single family.
Single family.
Then you need to treat it
Right.
right.
Okay, so this sounds like
So what
a,
are the costs that the city has incurred?
for us to consider.
So,
Know how I feel about this.
let him put his presentation, and then I'm going to tell you what my recommendation is because.
Yeah. So I'll try and be brief. I've met with the director several times on this. It's somewhat complicated.
Brief.
My client, actually, the guy that hired me is the son of the prior owner. Wasn't homesteaded. It was an older woman from France, and she did rent it out. Her tenant, I say this only on belief, and I know it's a horrible thing, but her tenant appears to have rented it short term. They didn't know about this until they went to sell the property and the liens came up. At that time, they ended up closing. This is in 2022. They closed, sold, thought it was over, and they agreed to deal with the fines after the fact. I still wasn't hired. They went and applied for mitigation online, and I was hired to come to the hearing. I came to the hearing, and then I realized, wait a minute, they applied as homesteaded, but they're an LLC. I didn't want to appear before this board under false pretenses, so I withdrew that request because it wasn't proper. So a few months later, the code changed to allow single-family homes that were not homesteaded to have mitigation. I then reapplied. Where this gets confusing is now my client hasn't owned this for a year. Someone else owns it. The ads from the tenant from like 2 years before were still up. So when I requested mitigation, even though it wasn't being short-term rented, no one's alleging it was, the ads were still up. So the case apparently kept running a fine, even though they had sold it and it was done years ago. That's why I involved the director. So really the period that there was a fine was very small. It just took 2 years to get this sorted out. They haven't owned it. The current owner is not short-term renting it. And now when we found out these old ads were still up, my client himself, who hasn't owned it for over a year, called the short-term rental websites and they all said, yes, sorry, these are old ads. We don't even have this property anymore. So it all got sorted out, closed. We were here on mitigation before, but there was no quorum, so we're back. So really, even though it seems like a long time, and I know that short-term rental and some of these cases have been horrible, this is not really one of those. Right. And this woman had rented it to someone, sold it. She just wants to get this over with. It's been 2 years. And the director has, I think, some thoughts as well.
Director, what do you recommend?
So at the time that he came originally, the fines had accrued to $69,000. Since then, it's increased further. We recommend a reduction of 90%, which makes the fine $6,900.
Wow. It's you?
Are you happy with that?
Wow.
Yes.
I am. and ask,
I would be too.
And ask the respondent if they're happy. Because I think this is fair.
Do I have a motion for $6,900?
I don't know. I don't know. I'm still thinking about it. You know, this is something.
No.
A precedent.
We have 50 cases.
No, it's a 90%.
We're leaving in 15 minutes. Him and I.
As a matter of fact, next week, Thursday, you're going to see multiple 90% reductions for full commission.
Do I have a motion? We have one of our board members that needs to leave in 10 minutes.
Okay.
We are leaving in 2 minutes.
Well, you've been saying you've been leaving a long time ago and you're still here.
Well, I just want to make a comment. The way I look at this is that
we need a motion.
The owner is responsible for the property, no matter what.
Right.
And whoever they rent to, it actually, to me, makes it even worse that they're not here looking at it, don't really care about it.
And it's new owners now.
Yeah, and even the new owners, we've still kept it in the family. Same thing, no disrespect. And the fact that they tried to homestead it, it's like, it further goes to show that they don't understand the laws of the United States or the code of the city, and the properties on both sides are single family. So
what do you recommend?
I'm recommending that we do a 50% reduction.
50% of
not a 90% reduction.
Can I just, if I may, just again, I know there have been some other extenuating cases. I know that she was not from this country, but she owned the property. There were never any complaints about an actual short-term rental. It was just ads that were found. I honestly don't know how much, or they had no knowledge of the rental. Had they known that they sold it, they only found out when it was for sale.
But that's
and I know that they don't live here,
they're
but
still responsible.
You know, I know that they're responsible, and we're here because they are responsible.
50% is $34,500. Do I have a second? Motion dies. Do I have a new motion?
I'll move for the director.
$6,900.
I'll
Do I have a
second that.
second? Do I have a second?
Second.
All in favor? Aye.
Nay.
Roll call. Thank you.
6,000.
Calling member Brenda Betancourt.
Yes.
Calling member Keon Williams.
Yes.
Calling calling member Rick Madan.
Yes.
Thank you. Calling chair Yvonne Bayona.
Yes.
Thank you. And calling member Keon Williams.
I say yes already.
Okay, I'm sorry. And then calling member Christy Tasker.
No.
Okay, it passes 4-1.
Thank you all. Have a good night.
Thank you.
Thank you. Good night.
Enjoy the game.
Next
Calling
case.
next case. Calling page 15. This is an extension of time. City view agenda. Address.
Page?
Address 3028 Southwest 21st Street. Case number CE 2021-012-707.
Wait,
Address,
what page?
This is page 15.
15? I have 15 as 1531 Northwest 70th Street.
You're looking at City View agenda?
Okay, City View, sorry.
It's a one page there.
Got it.
Page 15, and the address is 3028 Southwest 21st Street.
What are we doing?
Good evening. Please state your name and address.
Hello, my name is David Ojinaka. The address is 3028 Southwest 21st Street.
Okay, how many days?
Since 2021?
It's an
This
it's an
is for
extension of
mitigation?
time. It's an AOT. Extension of time.
Oh, an extension of time, I'm sorry. How much time do you need?
Roughly 120 to 180 days.
Been going on since 2021.
What have you done so far regarding the illegal units?
Yes. So I bought the house, and the previous owner did work without permit. So then I took on the process to understand what do I have to do. So of course I'm guilty because I'm now the owner. Then I worked very closely with Vanessa. She was very helpful in guiding me through. I made a few mistakes, I think, understanding how this whole thing works. And I'm now at the point where all the drawings are submitted and approved. I have the contract. I needed new contractors that basically are willing to work on stuff that they didn't initially do.
Right.
I need 3 contractors plus the general GC. I'm now about to pull the permit. I have 2 stamped and notarized forms from the contractors that I uploaded.
Right.
I built,
Right.
and I'm missing 2 with whom I already met at the building, so they know what was done, not only illegally but also wrong. So
Okay.
they have to redo stuff that the previous guys did.
Madam Chair, I think you.
Yes,
like
I
to
was,
hear
but I
from-
was waiting for the gentleman to finish speaking.
Thank you.
Sorry.
Good evening, Ms. Pino.
Good evening. Vanessa Pino, Co-Compliance Southeast Office. Just for the record, he wasn't the one who actually committed the violations. It was the previous owner. He wasn't aware. I got a complaint. There was an illegal unit in the rear. He got the people out. He's in the process of getting the permits. He's shown me his plans. He's been in constant communication with me. The plans and all that stuff is just taking a long time. But he's working towards
And what's your
compliance.
recommendation?
Yeah, would you
sorry?
recommend 120 days? He needs 120 or 180?
I would give him 180 just to save him maybe 1 or 2 more trips here because
Great.
it's been a while and it's been a very lengthy process for him.
Thank you. Do I have any further discussions, or do I have a motion for 180 days?
Motion for 180 days.
Do I have a second?
Second.
All in favor?
Aye.
You have
Thank you very
180. Good luck. Thanks.
Thank you.
Next case.
Calling page number 22. This is also City View Agenda. Address is 2511 Northwest 22nd Avenue. Page 22, City View Agenda. Case number CE 2019-009318. Page 22, City View Agenda, extension of time.
Good evening. Please state your name and address.
Good evening, members of the board. David Moscoso, 2525 Ponce de Leon Boulevard.
You are for an extension of time?
Yes, I am.
How much time do you need?
I'm asking for 90 days at this time so that we can come back and provide you with a progress update. As you'll notice, this violation is quite old.
Yep.
The reason for the record of inactivity is when I first took this case on, actually my client's mother was the property owner. She was bedridden. She really, unfortunately, did not have a lot of time left. She's since passed.
Okay.
Her husband had just passed, her father had just passed 2 weeks prior. She passed probably within 6 months of me taking her on as a pro bono client. My client then proceeded to go through the probate process, which was extensive. Unfortunately, it took a lot of our time. My client has procured a design review professional. The plans have been submitted. They were paper plans, so they were submitted to Blue Digital. Blue Digital has then passed them on to the city. I spoke with Mr. Osorio today at the city, and I asked him to send me a communication confirming that they had received the plans. I have a communication from Blue Digital that confirms that they submitted them to the city. Mr. Osorio has told me that Blue Digital is actually having issues with how they're processing the plans to the city, and to the extent that Blue Digital and the city have had some communications as recent as yesterday to revise the process by which they submit those plans. I've been diligent in communicating with Inspector Lezama at every step of the way. In fact, Inspector Lezama and I have been working together to connect my client with the community development program to help her in assisting with, with compliance in this matter. She's somebody who's very, indigent, has significantly less access to resources than a lot of the residents. And so I'm asking you for 90 days to come back before you with a confirmation that the plans are on the city side, with an update with regard to our communication with community development, and obviously keeping Inspector Lezama in up to date with our movements.
Mr. Moscoso, good evening. How are you? May I ask a question? How long ago, so technically, So I understand 9 extensions because we had COVID, et cetera. How long ago were you retained?
I was retained probably at the time of the first extension,
So a year ago.
if I recall correctly. And the reason why we've had so many, at the time of the last extension of time hearing that I appeared before this board, we were still in the probate process. And so we just cleared the probate process. That part is very difficult for her to process plans if she is not the property owner with the city. She is now. The plans have been sent to the city. She has undertaken the time and the expense to have those plans prepared. They are on the side of the city. I'm happy to communicate with you and Mr. Osorio to kind of confirm that tomorrow morning if you would like. Mr. Osorio said he would follow up and confirm that. Again, I've been diligent in communicating with Inspector Lozama with regard to this case, and I plan on continuing to be. I wish we could have closed this out for her sake, because this is an incredible stress on her end more than anything. And again, I would stress, this is a pro bono case for me. This is something I'm doing because I'm from the district, and very few of us have the opportunity to be from the district, become attorneys, and have a duty to really pay back to the community. So, I would ask that you take all that into consideration.
I agree. I thank you for that.
Motion.
Inspector?
I would also like to mention that without the clearance of the probate, they cannot apply for the community development program. So to take that in consideration.
Thank you. So you recommend the 90 days, Inspector?
No objection.
No objection? Oh, we
Max?
actually
Let's
need-
go 180.
Let's do 100.
I'll move to 180.
Second.
All in favor?
Aye. Thank you all so much. I'll be diligent in following up with you. Thank you all so much.
Thank you, Inspector.
Thank you,
Good
Board.
evening.
Thank you. Next case, please.
Excuse me. Calling page number 18. This is an extension of time in City View agenda. The address is 2451 Northwest 28th Street. Case number CE 2018-005210. Address 2451 Northwest 28th Street, page 18. City View agenda, extension of time.
Good evening. Name and address, please.
Omar Silva, the address is 2451 Northwest 28th Street.
Guilty or not guilty?
Extension of
Oh,
time.
extension of time,
Extension.
sorry. How much time do you need?
Estoy esperando ya solo el ok de los permisos porque ya todos están metidos ya. Hasta la...
How much time?
Waiting for the approval on the permits. ¿Cuánto tiempo necesita?
No sé, unos 120 días.
120 days?
120 days.
It's Homestead. I move for 180. He's not going to have anything done yet.
Do I have a second?
Second.
All in favor?
Aye.
180. Thank you.
Thank you.
Hopefully you will have everything done.
Next case.
God save you.
Calling the extension of time. This now is in the code check agenda. It is page 241, extension of time, code check agenda. Address 2970 Southwest 19th Street. Case number 00009805. Page 241, code check agenda, extension of time.
Good evening. Please state your name and address.
Good evening. Jackson Palingra, 2970 Southwest 19th Street, here on behalf of the owner.
How much time do you need?
180 days.
What have you done so far?
So this was actually quite similar to one of the previous cases that was on the extension of time. The owner purchased the property, was constructing a fence, didn't realize that the fence needed to be permitted, was cited for that, and then it was discovered that a prior owner had built an unpermitted addition, and so that has created problems in closing out the fence permit, and there was also a driveway issue. I've been in communications with Ms. Pino regarding the issue. We sort of hit a standstill with the contractor, but after speaking to city permitting officials, we determined that the next course of action was to apply for a zoning waiver. We've retained an engineer who has been out of the country until recently, but he was just able to come inspect the property. So we expect to submit the waiver application shortly and then get the permit closed out. But in an abundance of caution, we asked for the 180 days because of how long these things can take.
Thank you. Inspector Pino?
Vanessa Pino, Code Compliance, Southeast Office. He's been in communication with me. The violation was for the driveway and the fence, and when they started the permit process, I don't know if it was building or zoning, found the addition, and they haven't let them follow through with the other things until the addition is addressed.
So you agree to 120 days?
Yes.
You recommend that? Thank you. Do I have a motion for 120?
Motion.
180, sorry.
Motion for 180.
Do I have a second? All in favor?
Aye.
180. Thank you.
Thank you. Have a good
Have a
evening.
good night. Next case, please.
Calling page 238, this is extension of time, also on the code check agenda. Address 353 Northeast 54th Street, case number 000-52779. Address 353 Northeast 54th Street, page 238.
Good evening. Please state your name and address.
My name is Tim Lincoln. I own the property. I was asked to sign or execute a letter for the city of Miami, and I did.
I'm sorry. I just need your name and address.
230.
Tim Lincoln,
And your address?
450 Northeast 52 Terrace.
How much time do you need?
I don't know.
6 months.
Where are you at right now with,
I believe my tenants have hired an engineer or a professional, and that gentleman has paid his money to the city. So if you give me 180 days and allow me to close out the permits earlier and cancel my return visit, that would be just fine.
what is the city recommending?
Motion for 180 days.
Do I have a second?
Second.
All in favor? Aye. You have 180 days, sir. Thank you. Have a good night.
How many more cases?
Now we're
we
going
have?
to mitigations.
How many do we have for mitigation? Do you know?
Just a moment, 1, 2.
How many people actually present that you have to hear cases because I have to go, he has to go, we're gonna run out of quorum.
So you have.
You have about 8. There are some that are here in absentia. They either the power of attorney.
Don't worry about abstentions.
So you have 6 mitigations.
Then.
So let's
Okay.
plow through the
calling,
mitigation. I have counsel here on mitigation.
I'll give 5 more minutes.
calling mitigation. This is the City View agenda, page 1. This is address 1801 Southwest 23rd Street, case number CE 2017-019-083. This is page 1 in the City View agenda, mitigation.
How many days?
This mitigation is 1,470 days old.
It's a T3.
It's
Is it homesteaded?
too.
Homestead.
Good evening,
It's homestead.
please, sir.
I'll
Please
move for 0.
State your name and address.
Good evening. Gabriel Fernandez, 1801 Southwest 23rd Street, Miami.
I'll move for 0. It's a homestead.
Second.
All in favor?
Aye.
Congratulations, sir.
Thank you.
Wait for your order.
Thank you.
Calling the next case for mitigation, page number 248. This is, I'm sorry, yes, page 248, but this is in the code check agenda, mitigation. The address is 1742 Northwest 7th Street, case number 000-51046. This is page 248 in the code check agenda.
Good evening. Please state your name and address.
Raymond Carrero, on behalf of the owner, 9771 South Dixie Highways, Miami,
This is
Florida.
at 34 days.
34?
So members of the board, I'm glad that you're still here. So I am going to ask counsel for the respondent to table this matter. Because if we don't, court's position will be not to give any mitigations. You have multiple other open cases. This case was addressed by way of dry hour, and the venue in question is playing games back and forth with bringing prohibited uses. So I'm going to kindly request that it's reset, and we come back and hear them all together. There's an email that coming from the inspector.
Oh my God, I know which one.
Yes, so
Oh, definitely.
there's lots of issues. I'm not going to put them on the record. I'm just going to
Do
say
I have
that-
a motion to
Table.
reset this case?
Yes.
Motion. Second.
All in favor?
Aye. Okay, and if we can do it, so council has been here,
We'll give credit.
coming, and we haven't had quorum for a while, so if we can do it before the end of the month, it would be appreciated.
Right. I think by the end of the month,
to you
we'll
guys.
be able to put, I can in good faith, make a recommendation based on the ongoing activity.
And by then, our eviction writ will be executed.
Correct. So you
We have a final judgment of eviction that we just got.
Thank God.
None more.
And
Put that on the
we just need
record.
sheriff- We're just waiting on the sheriff.
I live close
waiting
by.
on
I
the
pass by there all the time. I know exactly.
Yeah, we're waiting on the sheriff to execute the writ.
So property owner, council is representing property owner who are going through an eviction process.
Okay.
The operator,
So
it's,
contact the director.
okay. So we're going to reset and we're going to
Yeah,
talk.
understood.
So that will be April 24th. That's the last meeting we have in April.
I'd rather go to May.
I'm sorry, May?
May.
Beginning of May?
Yes.
Next case?
Next case.
That'll be May 2nd.
All right, we're down to 4 mitigation.
Next case, next.
Come on.
Okay, calling the next case. This is also a mitigation. This is page 3. This is in the city view agenda. Page 3, address 524 Northwest 71st Street. Case number CE 2021-003-248. This is page 3, city view agenda, a mitigation.
How many days?
This one is at 266 days.
Page again, Melanie?
266.
Page 3, city view agenda.
This was
And
a
it's-
property, it was a
That's
single family
90.
home?
What was it?
No, I'm asking if this was used as a single family home.
Marcela.
Please state your name and address.
It would have to be.
Please speak into the mic because we can't hear you.
Raymond Coffee.
Address?
This is your case?
It's a marine
524
or
Northwest 71st Street.
automotive.
So your total is 65,500. 266 days falls under 90%.
What that means, sir, is that you have to pay 90% because the city commission adopted an ordinance that ties the hands of the board as to how much they can reduce the fine.
We can reduce them more.
It's 524.
It's an auto-related commercial establishment.
We can.
Yeah.
59,850.
Would you recommend that he
Go to the commission.
turn down mediation and go before the city commission?
Well, the problem is that the commission is going to say that he's not over the 271 days.
And we have to.
Right.
So the smartest thing for him to do as a T5 is to
just delay it.
Walk away. We shouldn't have raised this.
Shouldn't even raise this today.
Because he is in a catch-22.
Yeah. So let
It's-
it
it's a
cure some
T5.
more and then come back to us afterwards and then and go before them.
Right now, you're completely handcuffed as it relates to the process. And it needs to be reviewed.
Yes and no. We had, if you all remember, I don't know if you were on the board, but we had a couple where they appealed the decision of the board to the 11th Judicial Circuit. We entered into a settlement and brought it back to you to approve that settlement. That's
So-
obviously
resources.
From him.
Oh, it's a notice of appeal.
So, Director, let me just ask this question here. Would it be wise to have him turn down mediation?
Mitigation.
Turn down mitigation. Reapply for mitigation after the.
You have to do his first.
No, once the affidavit of compliance is done, that stops.
That stops.
Right. So he was stopped at 266 days or whatever it was.
Right, 266 days.
What we have had in the past is the board has entered whatever number. The property owner then files a notice of appeal in the 11th Judicial Circuit. We enter into a settlement and bring it back to you.
That's an option.
Yeah, but he's not going to know that.
Option B, if he wants to, I don't have a recommendation. I just,
He need to decide.
Our hands are tied, and if we vote on it, it's.
If they vote, it could be
It's
like
not
a
good for you.
10% reduction. So
It's 59,850.
That you would have to pay, sir.
In 20 days.
In 20
Wait,
days.
Which we all know.
Which means if he doesn't pay it in 20 days, then that means
Go
the
back to
affidavit.
66.
It goes back
All
up.
right, so perhaps what we should do is defer it to another day.
Yes.
Okay.
If you can meet with the director in the interim, and he'll explain the process to you. We're just trying to help you get the highest amount.
Right.
Reduce.
But right now,
We can't help
that
you.
highest amount reduction is only $10,000.
Right. So you're going to have
So
to
move
pay
it
for
motion
it.
to
Pay the
table it.
rest. So I'm going to hand the file to the director. Do you, sir, agree to defer this?
Move to-
Yes.
So-
Defer this case?
Motion
Do I
to
have a
defer?
motion? Second?
Second.
All in favor?
Aye.
Please go see the director.
Good night, everybody.
Wait, we're down
Calling
to
the-
3.
I have one more mitigation. Calling page 6.
I'm going to be late.
This is a mitigation in the City View agenda. The address
Oh,
is
there's only one more. There's only one more.
2132 Southwest 9th Street.
Page.
Case number CE 2018-007-381. This is page 6 in the City View agenda.
How many
This
days?
is at 658 days.
658 days?
Yes.
Yeah, that's 100%.
It's a T3.
Oh, okay, T3. So it's residential, single-family home.
And this
How
is
much
for
has the city-
outside, this is for outside storage of miscellaneous
Director, what
materials?
is the cost that the city has spent on this case? This qualifies for a single-family?
Single family, I
Yep.
would say at least $5,000.
Can you say
Okay.
his name?
Do I have a motion? Are you okay with $5,000?
You can
Do
pay
I
that.
have a motion?
Wait, can you pay that within 20 days?
He said yes.
Okay.
I make a motion
For 5,000?
for 5,000.
Do I have a second?
Second.
All in favor?
Aye.
Wait for the order. Thank you.
That's
Next
it?
case.
We're done?
One more.
Calling page number, it's an add-on in the City View agenda. It's underneath, behind the green page. This is add-on P1. Address is 48 Northwest 54th Street. Case number CE 2021-015-979.
How many days?
Russell.
It's at 63 days.
63 days. Good
It's a
evening.
T5.
State your name and address, please.
T5.
Hi, good evening. Eddie Baker, 1450 Brickell Avenue, Miami, Florida, 33131, representing the property owner.
I'm listening.
Is this 48 Northwest 54th Street?
48 Northwest 54th Street, yes.
Okay. I didn't know if there was confusion. We're before you today to request respectfully reinstatement of a mitigation that had lapsed. My client obtained the mitigation. His property manager passed away shortly after obtaining the mitigation, and it lapsed. So we are respectfully requesting that it be reinstated. We'll have it paid immediately. Thank you.
And we understood that the property owner had nothing to do with it. The manager who came to the hearing passed away.
Well, I have here 33 days. 63 days is 35%, so we'll come up to $11,025.
No, I'm sorry, I don't know if, so there was, the original amount owed was $31,500.
Right.
Yeah.
And a mitigation was granted for $3,750.
No.
That doesn't exist.
That is
For
inaccurate.
We
years.
don't grant those.
No. What happened is it was mitigated and it reverted because it wasn't paid. So
So why he's back?
So
council is back. I'm not sure how, but you're back.
I mean,
Retained for this.
Yes, just for this matter, but mind you, it came to my client's attention, the property owner, that his property manager, after obtaining the mitigation fee, didn't actually pay it. It didn't come to my client's attention until after the fact, long time later, once the property manager,
We can't do anything.
sorted.
No, we can't do anything.
You could give him another chance with the same amount.
Yeah, and again,
August
it was a unique situation. Just to speak to the actual violations, it's a vacant property, it's locked, it's gated, people have broken into the property,
The board
graffiti.
Okay, wait.
Did the property
Stop. We're
manager
in a
pass
hurry.
away?
Okay, hold on, Madam Chair. The board mitigated this on March 23rd to $3,750.
They didn't pay.
On March.
Well, I have this.
No. We went ahead and I think we reset the case to come back. We didn't, we had, so I do not agree with that.
I might have my facts wrong, because based on what I was told by the city, this was instituted, a mitigation was granted, and it lapsed, and I'm before you today to ask that it be please reinstated. I'm sorry?
The manager did not tell the property owner.
Well, but that's not
and he
Yeah.
passed away.
You have the
And-
death
Oh, he
Look,
passed
it-
away March 23rd. Okay, no, the board, Maritza was sitting as the acting chair and reduced it to $3,750.
But that was last year,
But
maybe.
that reverted.
No?
Last year, exactly.
Right, so it reverted, and he's requesting on behalf of the property owner who was not aware, we looked at the file, we had no objection. It's up to the board whether, again,
Do we have any proof of the property manager's name and a death certificate? This is
have
really
that?
simple.
Yeah, do you have that?
With me today, I do not.
Can we?
Okay, so I'm not believing it because he didn't even bother to submit a death certificate.
T5.
No, but this is council, okay,
But I mean, I'm just saying, but if we're blaming
an
the property,
attorney
the
would
dead
go
property
to the
manager.
Florida bar.
I mean, could I just interject for a second?
We've
you know-
lost quorum.
We lost quorum.
I can bring you back, but you'll have to bring back the property, the papers.
You,
Yeah, I mean.
you too, and I
death certificate.
I was unaware
What are
that
you
this.
asking him to bring back?
Bring back the death
I
certificate.
would
I'm so
suggest that you
sorry.
just bring back.
I'm really sorry.
I think what would help is if you brought back the death certificate for the property manager, proof that there was a property manager.
No, that the owner passed away. The property
No,
manager
it was the
did
property-
not tell the new
he
owner.
said Council.
Property manager.
Right, council, without that, they're gonna deny your request.
That's
So you
correct.
can accept
Understood.
whatever.
I wish I had the board's full attention and I wasn't being rushed out of here. Yeah.
And it's
I
really
just
difficult
I just
to
want the same
understand.
respect going both ways.
Well, I think you're doing.
People are just
We're doing
running
you
out
a
and-
favor, to be
No,
honest
I'm
with you,
trying to
because.
speak and, you know,
Well,
I
but at
want
least
to
we've
listen
lost
to you.
quorum, and you get a chance to bring the.
I'm
things
listening,
back.
so I'm sorry. Go ahead and speak, sir.
I was just trying to make a point that when these violations were issued, they were complied with immediately, within less than 30 days. The issue was the fines were not paid because the property manager was not communicating with the owner. I'm sure you're aware it happens. Nonetheless, we were granted the mitigation. The client relied on his property manager, who was running the properties. He owned several properties in the area, and he passed away. He's a state legislature. He's up in Tallahassee. He's in the district. He's in and out of the city.
But can I say something to you? Is it
Of
our
course.
fault?
Of
No,
course
it's
not.
not.
But the reason to institute fines is to incentivize compliance, and my client complied within 30 days with the violations. Right? If anything, it should be administrative costs. This is not a way to penalize
Okay.
property owners.
Can I have a motion
Yeah,
for
but-
$37.50?
But see, and that's what I don't, hold on.
5,000.
Can I just say
Five?
this? If you were given mitigation, mitigation, it's reduced. All right, so we've done our part at that point. We've
Right.
reduced it. Done, right? It expired. Now it's back to the full amount. And all we're simply asking, as a courtesy, where's the evidence of what you're saying? I get it, your client is a state
I'm
legislator.
saying it under oath here. I mean, I'm a
Right,
board
he's an
attorney and
attorney. He's
speaking.
not going.
You'd
yeah.
be
You know-
surprised. There's a lot of people come before us on the
Well, I'm in a unique
It's fine.
situation.
It's no
I'm just
different. A lot of people
speaking,
come before us. on
Would
the
you
road.
be-
under oath.
May I? Would you be okay with $5,000?
Wasn't ready?
Yeah, we
Let me
can.
tell you,
We're for.
Mr. Baker,
We have
Mr. Baker, I'm going to tell you that is huge because
Would you
you're
be
having a second bite of the apple.
okay to settle for $5 right now?
if we
And
could
you
do-
don't have to come back.
Yes.
Do I have a motion for $5?
Motion for 5.
Do I have a second?
I'm going to stay 30 seconds to say yes.
All in favor? Aye.
Aye.
$5,000?
Thank you very
We
much.
apologize.
No, I appreciate
This
your time.
meeting has
Thank you.
adjourned.
Coated and uncoated paper products, recyclable plastics, and reusable goods that can be taken home are all more environmentally friendly options. Let's work together towards a sustainable future by reducing waste in Miami's parks and beaches.
Part-time job, full-time hustle, all-time Shiro to all of us.
You nurture, we listen. You teach, we thrive. You lift our spirits, but we've got to lay down the truth. It's time for you, our Shiro, to stretch for the stars. A free online chat can give you the personalized tips you need to start boosting your retirement savings today. Start saving more for retirement so you can feel prepared and live your life to the fullest. Visit aceyourretirement.org.
Qui conséquence dépotoir illégal? Conséquence jeter fatra illégal yo important. Pour moun qui prend dans zak la, yo ka fait fasyon amant jusqu'à $15,000. Et même accusation criminelle dépend sous gravité offense la. Li important pour mettre action qui comportement à tolérer dans Miami. Et puis agir contre moun qui relève règlement gestion fatra yo. Image négative qui était créée par jeter fatra illégal, tout affecté réputation ville nous et puis li ka gen impact sur tourisme et croissance économique.